Assembly chamber. Signed. 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 Assembly chamber. Sound. 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 Assembly chamber. Sound.
Be seated. First item on the order paper today is member statements. Call Militia. Hugh.
Thank you, Speaker. Last Friday we commemorated the International Day of UN Peacekeepers, a day in which we reaffirm our commitment to investing in peace, which is the theme of this year's day. We also marked Red Cross and Red Crescent Day a few weeks ago. It's so important that we highlight, acknowledge and thank those who put themselves in harm's way in order to protect other people. However, such commemorations are not worth anything if we ignore what is happening on the ground. Airstrikes and ground fire have hit humanitarian facilities in Gaza. They have struck beside UN warehouses and they have left relief vehicles unusable. Health workers and emergency responders have seen their ambulances and destroyed in Iran, and their bases have been damaged. These are not tragic accidents. They are part of a wider campaign in which those who defend human dignity are treated as legitimate targets. Just 2 weeks ago, Israel intercepted a supply flotilla carrying humanitarian aid bound for Gaza. 428 participants were kidnapped and haunted by Itamar Ben-Gvir. Those actions highlight the Israeli state's disregard for international law and for the authority of the international community. This year's theme, Investing in Peace, resonates deeply on this island. Our own peace process was built through dialogue and international support. On this day, we thank those who put themselves in harm's way to protect people and to work for a lasting peace. Thank you very much.
Julie Middle.
Thank you, Mr. Speaker. I rise today, members, to pay tribute to a young lady whose life was violently stolen from her exactly 50 years ago today, on the 2nd of June 1976, after having been shot by IRA terrorists on the 23rd of May. Today, I ask you to forever remember the name of Linda Bagley. The Bagley family went through so much at the hands of terrorism, so much that they never should have had to endure. Within 2 years, they lost a beloved husband and father in another senseless and vile act of terrorism, to then lose precious Linda cruelly murdered around 100 metres from where her father had been murdered just 2 years before. To add to their pain, Linda's mother, Joan, was prevented from reaching Linda in her final moments due to a terrorist bomb scare outside of the Royal Victoria Hospital in Belfast. Linda's mother, Joan, who is now in her heavenly home, sister Lorraine and brother Graham have suffered more than any family ever should. There will never be any justification. Today I make no apologies for being emotional as I pay tribute to the precious life of Reserve Constable Linda Bagley, murdered at the hands of the IRA at just 19 years old. On Sunday, I was honoured to attend a remembrance service organised by SEF, where Linda's sister Lorraine, an incredible woman who I am so proud to know, spoke of her sister, her father, and the journey the family had been through. Linda was described as bubbly and full of life. Lorraine further said that after Linda's passing, our house became so empty. There was no laughter, just darkness and sadness. Through time and with the love and help of aunts and uncles, our church, Adjournment Parish, and the RUCGC family, we continued life as best we could, although we were forever mindful just how different life was without our precious dad and loving sister. Members, I am sure that you will all agree that having a father and husband stolen away in a violent manner and then followed by a daughter and sister stolen through a violent manner, both innocent individuals just 2 years apart, is simply unimaginable, a pain that no one should have to bear. Today, I ask simply for those perpetrators to examine their morality and their conscience. I call for truth and I call for justice. In loving memory of Reserve Constable William Bagley and his daughter, Reserve Constable Linda Bagley, both forever loved, forever remembered, and in Linda's case, forever 19. Thank you.
John Blair.
Thank you, Mr. Speaker. I rise today to mark World Peatlands Day, celebrated every year on the 2nd of June. This was established by the International Peatland Society, and the day highlights the vital role peatlands play in tackling the climate as well as nature emergencies. Peatlands are some of our most important natural assets. They lock away vast amounts of carbon, support unique wildlife, and act as natural water filters, improving the quality of our lakes and rivers, When degraded, however, they release carbon, increase flood risk and also undermine water quality. I am all too aware of these issues in my own South Antrim constituency, particularly regarding ongoing flooding along the 6 Mile River and the ecological crisis we continue to face at Lough Neagh. Yet, when restored, peatlands become vital in our efforts to meet climate and biodiversity targets. That is why I welcome the priority given to protecting peatlands by my Alliance colleague, the Minister for Agriculture, Environment and Rural Affairs, especially in publishing the peatland strategy and advancing its implementation. Additionally, the recently published wildlife strategy aims to support various projects to restore peatlands which have been damaged through wildfires. Recently, and joined by an Alliance colleague, I visited Divis Mountain to see firsthand the excellent work undertaken there by the National Trust and Northern Ireland Environment Link. Rich in upland heath, blanket bog and species-rich grassland, this site is proving to be an excellent example of ecological restoration. As part of their Divis, a View to the Future project, they have successfully made great strides in peatland recovery, helping to re-wet degraded peat, slow water flow, reduce erosion and support carbon sequestration and the recovery of native species. And I think the reduction in flood risk there is of particular note to the Greater Belfast area. In conclusion, Mr Speaker, peatlands are crucial for achieving our climate change goals. We need to continue supporting their protection and restoration by backing the Minister's efforts to enhance these sites, along with organisations that are at the forefront of peatland restoration. Thank you.
Colin McGrath.
Yesterday was the 1st of June, and over the last 2 months this Assembly has debated legislation, it's discussed policy and generated countless headlines. And this week more legislation will progress through this chamber. Yet somehow or another, as we stand here today, what still has not progressed is a budget. Not a 3-year budget, or even a 1-year budget, which is a basic responsibility of government, and it remains unfinished. That failure has consequences far beyond this room and far beyond this building. It affects every department, every public service and every community that relies on public services. And nowhere is that clearer than in our health service and in the treatment of our nurses. Every year we know how many nurses we employ. We know what pay bands they are on. We know pay awards will have to be funded. And none of this comes as a surprise. Once upon a time, these were treated as inescapable, and so they are. Then why does this executive continue to leave it to the last minute to try and juggle Barnett consequentials or in-year monitoring rounds to find the necessary money to pay awards at the very last minute? Year after year, nurses are left waiting to hear what their pay award will be and if pay parity will be maintained. And while they wait, health trusts are left in deep uncertainty, because if funding for pay awards is not built into the system from the outset, then the trusts inevitably come under pressure to find that funding or efficiencies elsewhere. Call them what they are. They are cuts to the service. And the longer that this cycle continues, the wider the gap grows between what nurses receive and what their colleagues elsewhere receive. And pay parity affects patient care. That's as basic as it gets, because when experienced nurses leave and when vacancies remain unfilled, when staff feel undervalued, patients feel the consequences. We then resort to spending more and more money on agency staff. And meanwhile, the public are forced to listen to an endless blame game. One minister blames another, then Stormont points at Westminster, then Westminster points back. And you know what? It's all becoming utterly desperate, depressing and dull. People outside this building don't care who it is that takes the responsibility. They just want somebody to do it. And they simply expect those who sought the privilege to govern to actually govern and take those decisions.
Colin Gildernew.
Ceann Comhairle, and I rise this morning to once again, Ceann Comhairle, raise the issue of odours affecting communities across South Tyrone. It's deeply frustrating that we see continuous repetitions of issues going on, and there are two individual communities that are particularly impacted by this, communities in the Kilishal and Cabra area, and also separately residents in the Granville and Eskra areas. In recent weeks there has been a serious gas leak in relation to the Granville issue, an issue that was reported as far away as Eglish, 4 miles away, and required attendance by the fire brigade. Such was the concern. I met with NIA again last week in relation to both these issues, and I have to say that once again they have committed to investigate and review, and I have no doubt they will. However, communities are increasingly frustrated that the same pattern is repeated over and over again in relation to these issues. A review is carried out. In some cases, enforcement action is put in place. In others, enforcement isn't. However, the problems continue throughout, and eventually the enforcement action runs its course, the company continues on its way, and the community continue to suffer. And this is simply not good enough, and I think we actually need to look at very seriously now at an independent environmental agency which will protect communities and stand up to these companies and ensure that some difference is made in relation to these issues. Just can't continue to repeat over and over again. And I have to say, if members don't understand, the impact of this in both areas is such that people actually have to cancel outdoor events, they have to cancel children's parties, training has had to be cancelled at the local sports clubs, schools have had to keep children indoors. So this is not acceptable, and it's simply not sustainable that it keeps happening over and over again. The agencies that are tasked with doing this must also have the legislation and the resources to make a real difference. So I'm calling now on a serious look at this issue, particularly in the South Tyrone. It will be affecting many people across this chamber, in your own areas as well. And you're probably experiencing the same frustrations and difficulties that I am. But whatever happens into the future, we need to ensure that communities are protected and that companies are effectively regulated to ensure that that can't continue to happen.
Well, Peter Martin.
Thank you very much, Mr. Speaker. On Thursday of last week, I was made aware that the Children's Commissioner, Mr. Chris Quinn, had endorsed a position where no young person under 16 should be prosecuted for serious crimes like rape, murder or sexual assault. Full credit to David Thompson, the journalist from the newsletter, for some journalism to highlight this position in the first place. And there is a disturbing context to this. Recently in Hampshire, 2 girls aged 15 and 14 were raped in separate incidents by 2 14-year-old boys, and another boy, 13, was also convicted in the attack. Members may have noted in the media coverage that none of the boys in the initial sentencing were given custodial sentences. Thankfully, in this case, the Attorney-General is reviewing the case. If these rapes had occurred in Northern Ireland and we had adopted the Children's Commissioner's position, which some in these chambers endorse and other parties are not far from, these young girls would have had no access to justice. And for me, that's simply unacceptable. I want to be clear that every child deserves protection, every child deserves support, every child deserves the opportunity to turn their life around. But we must also remember another fundamental principle, that every victim deserves justice. When we talk about serious sexual crimes, we are not talking about youthful mistakes or minor acts of wrongdoing. We are talking about offences that leave lifelong scars on victims. We are talking about crimes that destroy confidence and leave families devastated. The first duty of any justice system is to protect and uphold the rights of innocent victims. That principle cannot be abandoned in the debate that we are having, and the DUP will support all victims and make the case for equitable justice across Northern Ireland. I wrote to Mr.
I'll just remind you that we're not to preempt the debate that's to take place around the middle.
No. Thank you, Mr. Speaker. I wrote to Mr. Chris Quinn on Friday to ask him a range of questions. Do children under 16 possess an equal right to criminal justice when they are raped by boys under 16? What message do you believe your position, as outlined, sends to girls who are already fearful of reporting rape due to low conviction rates and traumatic processes. And finally, given the fact that we as a society are struggling to deal with violence against women and girls, how can you justify a position that states that boys under 16 should not be prosecuted for rape? I'm still waiting for a reply from the Children's Commissioner's Office, and in fact an acknowledgement of my email to him, and hopefully he will clarify his comments to me. These are incredibly serious crimes that we are considering, but they do occur, and when they do occur, victims want justice. We will stand up for the victims in that debate, and even if we have to stand alone, we will stand for the victims of these crimes. Thank you, Mr. Speaker.
Speaker, and I rise today to talk about the abuse of a protective mechanism by one party in this chamber. I got involved in politics 15 years ago because at my core I believe in social justice. I believe that it is the duty of every single one of us to fight for a more fair and a more equal society. And when the majority of our communities and our societies here in Northern Ireland in 1998 voted for the Good Friday Agreement, that's exactly what they voted for as well, to work for a more fair and a more just society. And that's why we needed protections at that time, like the petition of concern. We needed those protections so that decisions could not be imposed on one section of our community and to encourage power sharing. So for the Democratic Unionist Party to lay petitions of concern against amendments on legitimately held policy decisions just because they do not agree with them is an affront to democracy, and it is an affront to the protections that those petitions of concern and mechanisms were designed to put in place. Debate the issues, bring us the evidence, bring us your reasonings for not agreeing with the debate, but do not abuse this chamber and the protective mechanisms that are put in place. In 2016, my party said that we needed a reform of the petition of concern. At the time, the Democratic Unionist Party leader Arlene Foster agreed. The petition of concern needed to be changed. And here we are, 10 years later, with one party because they do not agree with the policy and they don't think that they have the numbers to actually legitimately and democratically win an argument. They've put in a petition of concern. If any of the members that have signed that petition of concern want to approach me today and tell me how any of the amendments that I and others have laid before this House legitimately either discriminate or in some way disenfranchise a portion of our society, or indeed the constitutional status of this place, I'm all ears, because that's what the petition of concern was designed for, not because you don't agree and that you might not win the debate. It is time for reform, and it is time that the petition of concern and other protective mechanisms are not abused because you won't win the argument or you don't agree with the proposal on the table.
Tom Buchanan.
Yesterday marked the commencement of Volunteering Week, when all those throughout Northern Ireland who gave of their time in a voluntary manner and other organisations are recognised for the sterling work that they do. And it was a privilege to meet with a number of groups in Omagh yesterday and present them with certificates in acknowledgement of the work that they've done, not only throughout the past year, but throughout many previous years. These are the people who quietly, through their dedication and undivided commitment, breathe life into the heart of our communities, keeping them strong and people focused. And in many towns and villages throughout Northern Ireland, these are the individuals who willingly give their time, their energy and their compassion, not for praise and not for reward, but because they care about the people around them. Volunteering is one of the greatest expressions of citizenship, yet it is the work that never makes the headlines, but the work which holds our communities together. Whether it is supporting the vulnerable, organising local events, coaching young people, or simply being there when someone needs a helping hand, their contribution matters so much to them and makes a real difference to their lives. And today I want to acknowledge that service that they deliver. It is about saying very simply, but with all sincerity, to the volunteers, thank you. Thank you for the hours that you give, for the skills that you share, for the example that you set, reminding us that community spirit is something we build day by day throughout acts of kindness and commitment. And throughout my years as an elected member, I've witnessed day by day the huge impact the work of volunteers have made on our communities. To see the difference they make in homes and neighbourhoods and in the lives of people who may never know their name, but will always feel the benefit of that generosity that is delivered by them. And today, standing shoulder to shoulder with our volunteers, and on behalf of those who can testify of their lives having been touched by the sterling dedicated work of the volunteers, I want to express my sincere gratitude, because it's that service that strengthens the community spirit in this little place that we call home. Thank you.
David Honeyford.
Mr. Speaker, over the month of May, Manufacturing NI rightly shone a spotlight onto one of our greatest economic strengths. Manufacturing contributes more than $6 billion to our economy, supports over 100,000 direct jobs and creates opportunities right across this region. But too often our focus on future economic growth can be on attracting the next major inward investment, rather than looking at growing our economy and backing the business and workers and innovators that we already have here and helping them to scale. Our manufacturers invest in innovation, they invest in R&D, they create high quality, good jobs, and they export their products around the world. But manufacturing is ultimately about people and opportunity. It's about delivering skills and helping make things. It's about creating opportunities for people to build a better future that in this place that they call home. And Alliance believe that we need to be much more ambitious. Despite the importance of the sector, we still lack a dedicated manufacturing strategy, and we need a strategy focused on removing the barriers to growth, addressing the skill shortages, reducing energy costs for manufacturers, supporting innovation and export opportunities, and tackling planning delays and wastewater connection constraints. Most importantly, it must contain clear priorities, actions and timelines. We should also be collaborating across this island on a range of these issues, on skills, on energy, on supply chain opportunities, on human resources. We need to look at these areas and make practical economic sense and work together to deliver better for everyone. And if we look south, manufacturing has been recognised as central to their success and their economic growth and regional prosperity. 85% of the jobs in the south, in the manufacturing sector in the south of Ireland, are outside of the Dublin area. So you naturally bring the jobs across the region looking at this and tackling this. But their success didn't happen by accident. It came about by creating the conditions for businesses to invest, to grow and succeed. And we need to be doing exactly the same. Manufacturing is not an industry of the past. It is one that the future and our foundations of the future are built on. So if we're serious about growing our economy, creating good jobs and building opportunity across Northern Ireland, manufacturing must be central and at the heart of that ambition. And I want to thank Manufacturing NI for the outstanding work that they do to highlight and celebrate their industry and the businesses that we have here, and the workers that create and make those businesses thrive and grow. And I want to congratulate them and wish them all the best into the future. Thank you, Mr. Speaker.
Jerry Carroll.
Thank you, Mr. Speaker. I want to briefly mention a workforce dispute that's coming to a head in the coming days, and raise members' attention, bring their attention to it. Erskine House is known to many people here. Some of us, myself included, have been outside it on many occasions, protesting against government decisions. Occasionally I've been inside it, having meetings with ministers and officials, and members here have done so similarly as well. But Erskine House, like this building, Mr. Speaker, doesn't just exist out of thin air. It exists due to the work and the labour of people who are employed to clean, to act as porters, receptionists and other roles inside the building as well. The workers in Erskine House are in the PCS trade union and have voted, 100% of them have voted to take strike action And the nature of the dispute, Mr Speaker, is against forced redundancies, and unfortunately this is something we're seeing across different sectors and across the board, where staff and workers are being told by management and by companies that they no longer have a job. So the workers in Erskine House who are employed by Sodexo will take strike action later this week. It's worth members understanding, I'm sure they know already, that this isn't some small-scale corner shop cleaning company. This is a huge multinational organisation that operates in some 45 countries across the world and made at least £1 billion in profit last year. So these are vital workers who keep Erskine House operating. They keep it clean, they allow people to come in and out of the building, they supply food in the building, and the building obviously does not operate without their labour, Mr Speaker. So there's strike begins on Thursday, and I'm calling on, whilst it's not directly the responsibility of the First and Deputy First Minister, I think pressure from them could help resolve this dispute. And we're calling on them to intervene, to put pressure on the British Government, on the Prime Minister, on the Secretary of State, Hilary Benn, because it is the British Government that are paying Sodexo, and Sodexo who are coming for workers, and call on those ministers to intervene, to put pressure and stand by the workers who are keeping the building operating. The first picket line begins on Thursday at 12 o'clock, and PCS are extending a welcome to everybody here, and obviously all members of the public who are interested in workers' rights to come along. Thank you.
Timothy Gaston.
Mr Speaker, I want to bring you a tale of two listed buildings. One, a beautiful building central to the history of Northern Ireland and its founding. The other building, an ugly group of buildings judged to have no architectural merit. The first, of course, is Craigavon House, a historic Victorian mansion built in the 1870s, home of the Craigavon family. From its steps, the Ulster Covenant, the birthright of Northern Ireland, was first read. And it was, of course, the nerve centre from which the historic UVF, which went off to fight and die for freedom on the fields of France and Flanders, was formed. In spite of the promises contained within the New Decade, New Approach Agreement, it has been sadly left to wreck and ruin. The other group of buildings I want to address is at the Maze. They were judged by the Historic Buildings Council to have no architectural merit. They were constructed in the 1970s, and yet they have had £324,000 of public money spent in them for their upkeep. Why? To preserve the hospital wing where Bobby Sands killed himself, and to keep an IRA shrine up to standard. Keeping those obnoxious buildings offers nothing for future generations. Keeping these buildings is blocking regeneration of this site. Keeping these buildings is stopping inward investment and job creation. Mr Speaker, a Adjournment which preserves one listed building associated with those who want to destroy Northern Ireland, while leaving the other associated with those that want to destroy. So we need to get rid of that blight. That is not a Adjournment delivering for unionism. Picking and choosing, keeping those with a blight to Northern Ireland while leaving the other associated with the founders of Northern Ireland is indeed not one delivering from unionism. I want to see inward investment. I want to see development at the Maze, but that cannot happen while the hospital wing and the associated buildings connected with that shrine are left in place.
Okay, members, that brings to a conclusion the time available for members' statements. We now move on to the consideration stage of the Justice Bill. And I do want to acknowledge that we have approached the scheduling of this bill somewhat differently than in the past. Members will know that I have said before that we needed to learn lessons from the last mandate, and that includes seeking to debate legislation in unrealistic timeframes and therefore ending up accidentally sitting until the early hours and squeezing debate, which doesn't produce the scrutiny that I think is required. I therefore want to thank the Minister, the Committee and the Assembly and departmental officials for their cooperation and agreement to proactively plan for this debate and to agree to schedule it over several days. We will see whether the 3 days that is scheduled is sufficient. It may not be, but nonetheless it demonstrates the seriousness that we're given to this really complex bill with a number of amendments that we have never actually faced before. So we now move to the consideration stage of the Justice Bill, and I call the Minister of Justice, Mrs Naomi Long, to move the bill.
So moved, Mr Speaker.
Thank you. Members will have a copy of the marshalled list of amendments detailing the order for consideration. The amendments have been grouped for debate in the provisional grouping of amendments selected list. There are 9 groups of amendments, and we will debate the amendments in each group in turn. The first debate will be on biometric data and police photographs. The second debate will be on child bail, custody and live links. The third debate will be on offences. The fourth debate will be on police discipline and police barred advisory lists. The fifth debate will be on drink drug driving measures and police seizure of vehicles. The sixth debate will be on minimum age of criminal responsibility. The seventh debate will be on restorative justice, rehabilitation of offenders and criminal record certificates. The eighth debate will be on legal aid and technical changes. The ninth debate will be on prisoner discharge and accommodation. I remind members intending to speak during the debates on the 9 groups of amendments in opposition to Clause 28 stand part, they should address all the amendments in each group on which they wish to comment. Once the debate on each group is completed, any further amendments in the group will be moved formally as we go through the bill, and a question on each will be put without further debate. The questions in stand part will be taken at the appropriate points in the bill, and if that's clear, I think we should proceed. We now come to the first group of amendments for debate. With Amendment 1, it will be convenient to debate Amendments 2 to 40, 66, 67, 99, 102, 104 to 120 and 122 and 126. Any links between the amendments in this group will be indicated at the appropriate point. I now call the Minister of Justice to move Amendment 1 and to address the other amendments in the group. Minister.
Mr Speaker, I beg to move Amendment number 1 to the Justice Bill. Before turning to the amendments, I would like to take this opportunity to register my thanks to the Committee for its support and commitment in completing their scrutiny of the provisions of this bill and the proposed amendments. I would also like to thank the current and previous chairs, deputy chairs and members for their engagement throughout this period and for their subsequent support of all the substantive provisions of the bill at introduction and their endorsement of amendments that they scrutinised during the committee stage. The Committee has brought forward a very small number of modest amendments, including a regulation-making power to provide for the retention and use of photographs in Part 1 of the bill that we are about to debate shortly. The Committee's other amendments include tweaks to Clauses 4, 5 and 6 in Part 2 of the bill to include a child's vulnerabilities as a relevant consideration to be taken into account when a decision whether to release a child on bail or to impose bail conditions is being taken by police or courts. The inclusion of a review mechanism for the use of live links by police in Part 3 of the bill, and a consequential amendment to Clause 33 of the bill to specify a time frame for the commencement of the biometric provisions of Part 1 of the bill within 5 years of royal assent. I very much appreciate the Committee's consideration of these issues, and I look forward to debating its amendments at the appropriate point in our proceedings. Before I speak substantively to the nature of the changes to be made to Part 1 of the bill in my name, I want to address some of the concerns that I understand the Chair of the Committee for Justice may have had in terms of the text of the amendments tabled on my behalf by the Office of Legislative Counsel, compared to the format provided to the Committee at the start of the committee stage for publication as part of their call for evidence. I want to reassure the Chair and indeed the members of the Committee that there have been no substantive changes to my amendments in either policy intent or outcome. While the amendments may have been presented differently, reflecting the sequence in which the amendments are made to the bill and the consequential nature of a number of the amendments, and any changes to the text of the provisions reflects drafting tweaks and technical adjustments to ensure the amendments work as originally intended. There is no change of policy approach or any new policy content that the Committee have been undecided on. The committee's scrutiny of these amendments is therefore unchanged, and again I express my thanks for the diligence with which they undertook that work. Mr Speaker, the bill that I introduced to the Assembly in September 2024 has 4 key principles: to amend retention periods for biometric material, to make changes to bail and custody arrangements for children and young people, to improve services for victims and witnesses, and to improve the efficiency and effectiveness of aspects of our justice system. Part 1 of the bill creates a new framework for the retention and destruction of DNA and fingerprints in Northern Ireland, and I want to now speak to the amendments that are tabled in my name to this part of the bill. The package of amendments to Part 1 of the bill that are tabled in my name are as a result of stress testing the draft legislation with PSNI, which identified a need for some modifications to the provisions of the bill at introduction to provide greater clarity in what is a complex area and to ensure for the effective operation of the new framework. I don't intend to labour the detail of each of the provisions in this grouping, which I'm sure will be a relief to all the members in the Chamber, as a number of the amendments are consequential in nature, but I can provide a summary of the nature of the amendments, which are as follows. A number of amendments are made to Schedule 2 of the bill, beginning with Amendment number 108, to replace the term reported with the term complaint being laid against a person in Part 6 of PSNI, which is due to the term reported having different interpretations across the criminal justice system, and so this amendment is designed to provide legislative clarity. Existing references to being charged with an offence or informed that he will be reported will be replaced by being charged with an offence or where a complaint has been laid against the person. Amendment 22 makes changes to retention periods for DNA and fingerprints held on foot of a community-based restorative justice scheme, as standalone community-based restorative justice schemes directed by the PPS are considered to be on a similar level to a caution. This amendment and associated consequentials will ensure that standalone community-based restorative justice schemes attract the same retention period as a caution for adults, i.e. 75 years or 25 years, and 5 years for someone under 18. There are provisions to create a grace period for DNA and fingerprints being held for individuals under investigation, wherein the amendment provides for a 28-day grace period to ensure the PSNI have sufficient time following the conclusion of an investigation to either lawfully process the deletion of an individual's DNA and fingerprints or submit an application to the Biometrics Commissioner for continued retention. Next, Amendment 8 makes a change relating to the applications to the Biometrics Commissioner, which will provide clarity that the DNA and fingerprints of an individual arrested but not charged can be retained by the PSNI until the outcome of an application made to the Biometrics Commissioner is known. There are new provisions to establish a power to photograph individuals in specified circumstances at a police station at Amendment 66, thereby putting photographs on the same footing as DNA and fingerprints regarding the powers of the PSNI to recall an individual to a police station for material to be taken. There are also powers in Amendment 67 to specify a date of attendance at a police station for the taking of DNA samples, fingerprints and photographs, so as to improve the process of making arrangements for requiring an individual to attend a police station for their material to be taken and to reduce the likelihood of an individual attending the station and custody staff not being available to facilitate the taking of that material. Amendment 111 makes changes relating to informed warnings and restorative cautions, which will provide clarity that any reference to a caution in Part 6 of PSNI is to be interpreted as including an informed warning or restorative caution. Provisions in new Article 53B in Amendment 17 mean the existing references to cautions in Articles 61, 63 and 64A are no longer required, so there are amendments to remove those redundant references. And finally, there are regulation-making powers to require that any future regulations to accommodate changes in the terminology used for informed warnings or restorative cautions, or regulations dealing with transitional arrangements for DNA and fingerprints must follow the draft affirmative procedure. Mr Speaker, I now want to turn my attention to the amendments that I mentioned at the outset that the Committee for Justice has proposed for inclusion in this part of the bill. The Committee's first amendment is Amendment 40, which creates an enabling power to allow for the inclusion of photographs and other emerging technology under the definition of biometric material retention provisions in Part 1 of the bill. and commencement of new DNA retention framework, a second amendment, Amendment 104, is consequential to Clause 33 of the Bill to require the Department to bring the new retention framework contained in Part 1 of the Justice Bill into force within 5 years of royal assent. While I am generally content to accept both the amendments in principle, there may be some technical points amendments tabled to Part 1 of the Bill by Ms Emma Sheeran, Ms Aoife Finnegan and Mrs Ciara Ferguson. While the intention behind Amendment 5 is not entirely clear, it appears to relate to Article 63I, which deals with cases left on the books. In certain criminal cases, the PPS may invite the court not to proceed with a charge, but instead to have it left on the books. I consider it both reasonable and proportionate to apply a time-limited retention period in these circumstances, given that proceedings may be recommenced. The Department's consultation in 2020 included an initial proposal for a standard 12-month retention period. However, several respondents questioned whether the 12 months would be sufficient. Based on the evidence available to the Department, a decision was made to amend the original proposal to a 3-year retention period for qualifying offences and 12 months for non-qualifying offences, therefore ensuring a differentiated and proportionate approach, and I am satisfied that that remains appropriate. Amendment 11 relates to qualifying offences which are listed in Article 53A of PSNI and include the most serious, violent, sexual and terrorism-related offences. Given their seriousness, I consider the maximum retention period of 75 years to be necessary and proportionate for both adults and those under 18. However, it is important to note that the statutory review mechanism will include earlier statutory review points for young people than for adults, which will provide an early opportunity to consider if it remains necessary and proportionate to retain that person's material. I am therefore satisfied that the current proposals are both proportionate and appropriate. The proposed new Article 63JA at Amendment 12 would introduce a 3-year retention period for individuals under 18 who are convicted of a qualifying offence and a 3-year retention period for those under 18 convicted of a non-qualifying offence, subject to approval by the Biometrics Commissioner. These proposals have not, in my view, been sufficiently developed or tested. Moreover, the proposal to remove existing Articles 63L, 63M and 63O by Amendment 13 would dismantle the less stringent regime designed specifically for under 18s. I believe the provisions included in the bill should be retained as a key component of the framework. They provide an appropriate balance between safeguarding young people's rights, respecting victims and maintaining public safety. As I previously pointed out, the review mechanism will provide additional safeguards, including shorter timeframes for under 18s before mandatory review. The removal, Amendments 23 and 24 would remove Article 63P, which provides a 5-year retention period for diversionary youth conferences and community-based restorative justice schemes. Both are directed by the PPS and represent a step up from community resolution notices, with restorative justice schemes broadly equivalent to a caution. It is therefore appropriate, in my view, that they attract a 5-year retention period for under 18s, and I am of the view that this provision should remain. Amendment 28 would remove Article 63Q, which provides a 2-year retention period for penalty notices issued to adults under Section 60 of the Justice Act NI 2011. This aligns with the approach in England and Wales and applies to penalty notices issued for a defined set of recordable offences as follows. Indecent behaviour, S9 of the Criminal Justice Miscellaneous Provisions Act, Northern Ireland 1968. Shoplifting, Section 1 of the Theft Act, Northern Ireland 1969. Criminal damage, Article 3.1 of the Criminal Damage, Northern Ireland Order 1977. Disorderly behaviour, Article 18.1a of the Public Order, Northern Ireland Order 1987. Behaviour likely to cause a breach of the peace, Article 18.1b of the Public Order, Northern Ireland Order 1987. Resisting, obstructing or impeding a constable, Section 66.1 of the Police, Northern Ireland Act 1998. I am satisfied on balance that this provision is proportionate and appropriate, and it should stand part of the bill. Article 63T provides an important safeguard requiring periodic review every 5 years of material retained for long-running ongoing investigations. This is distinct from the provision in 63U, which requires the review of long-term retained material held on foot of a conviction. The provision at 63T recognises that some investigations, such as, for example, unsolved murders, can remain open for some considerable time. However, it provides a safeguard to ensure that an individual's material is not held any longer than strictly necessary. Amendment 29 would require the PSNI to notify an individual that they are subject to such a review and then enable an appeal process, which would potentially risk undermining an ongoing investigation and is therefore not appropriate. Nor is it appropriate or indeed workable for anyone other than the PSNI to carry out such a review. I'm satisfied the current provision appropriately balances safeguarding an individual rights with operational effectiveness, and it should remain unchanged. The appeals process for decision arising from reviews conducted under Article 63U is the next amendment that is considered. This proposed amendment seeks to exclude PSNI personnel from determining appeals against a decision to retain material after a review. Under the current proposals, requests for review will be handled by a designated PSNI team. Where an individual seeks reconsideration, the decision will be reviewed by a different and more senior officer with no prior involvement, ensuring procedural independence. This two-stage process reflects established best practice, for example in FOI procedures, and balances fairness with operational practicality. PSNI is the data controller and is best placed to make decisions on the necessity of continued retention in the interest of investigating crime and public protection. It is therefore appropriate, and I would argue necessary, that PSNI has responsibility for this process. However, and in addition, individuals may complain to the Biometrics Commissioner, who can require reconsideration or deletion where retention is unlawful. The Chief Constable will be obliged to comply, and I am satisfied that those combination of safeguards for individual rights are sufficiently robust without compromising public safety. Article 63Z already contains an enabling power for the Biometrics Commissioner to issue guidance. As an independent office holder, it is appropriate that the Commissioner determines whether and how such guidance is issued and what should be included within it. Making guidance mandatory and then prescribing its content, as Amendment 35 does, would risk undermining that independence. I do not think it appropriate for my department to establish an independent office and then direct at this level how it should exercise its functions. In conclusion, Mr. Speaker, the provisions of Part 1 of the bill are extensive, complex and intricately interlinked. The proposed amendments that I have just spoken to propose to make isolated changes to individual aspects of a carefully drafted suite of provisions contained within the bill. To do so risks rendering part of the new biometric retention framework inoperable through bad drafting, technical deficiencies and potential unintended consequences. As such, I do not support any of those amendments. Finally, in respect of Part 1 of the bill, Mr Jerry Carroll has tabled Amendment 38, which includes provision that individuals should receive written notification when their retention period changes as a result of the making, renewal or expiry of a national security determination. NSDs can authorise a retention period of up to 5 years for DNA and fingerprints where this is necessary and appropriate for national security purposes, and they are subject to review by the UK Biometrics Commissioner. The legislative provision relating to NSDs are set out in the Protection of Freedoms Act 2012 and fall within the responsibility of the UK Government. As such, paragraph 2C of Amendment 38 would fall outside the legislative competence of the Northern Ireland Assembly. The amendment also contains some issues that are within the competence of the Assembly, but they are more appropriately addressed through updates to PACE Code D, which will be subject to public consultation and indeed to committee scrutiny. The revised code will be introduced alongside the new retention framework. I therefore do not support this amendment. That concludes my opening remarks on this group of amendments to the bill, Mr Speaker, and I look forward to hearing and responding to the views of the members present and hope that this will be a constructive and positive debate. Thank you.
Paul Fruit.
Mr Speaker, with your indulgence, before addressing the first group of amendments, I wish to make some general remarks about the bill in my capacity as chairperson of the Justice Committee. Can I first place on record my thanks and appreciation to the Minister and the Department for all the communication, all the letters, all the presentations, all the evidence sessions that they were part of to help and aid the committee scrutinise this bill. I'd also like to thank my predecessor, Joanne Bunting MLA, now Junior Minister, who was the chair of the committee for a significant part of the committee's scrutiny of the bill. I would also like to thank all the previous members of the committee for their work during the committee stage, which was long and extensive, and there was a bit of churn. So everyone who had sat on the Justice Committee and who had played a part in the scrutiny of this bill, I thank you for that. The bill, as introduced, deals with a range of significant matters, with 34 clauses and 4 schedules. However, the committee knew before the bill's introduction that there were planned ministerial amendments covering another 6 policy areas. Members felt that affording those amendments proper scrutiny was the right thing to do. The committee therefore agreed that a lengthy committee stage was necessary, and the extension was subsequently agreed by this chamber. Despite the best efforts of the committee to try to complete its work before that deadline, it regrettably took the full 18 months to conduct its scrutiny. A large part of that came down to the complexity of the provisions in the bill and the planned amendments, which required detailed consideration by the committee. The bill includes a detailed biometric retention framework with potential human rights implications, which was further complicated when the committee was advised of the need for amendments to those provisions just days after the bill's introduction. The biometrics provisions were the subject of lengthy discussions, not least in terms of what is not covered by the provisions. This culminated in the committee agreeing to bring amendments relating to that part of the bill, which I will talk more about later. The bill makes changes to bail and custody arrangements for children and young people. Again, there was detailed and lengthy discussion on this part of the bill, as it was important that members fully explored the implications for children and young people. We know that live links are in use in courts and tribunal proceedings by virtue of provisions in the Coronavirus Act 2020. The committee examined the proposed ministerial amendments to make primary legislative provision for live links in courts and tribunals, alongside the new provisions in the bill for the use of live links in police custody. It is recognised that the use of live links can be a benefit, not least in terms of speeding up justice. Representations made to the committee included the need to ensure that people were fully advised of and understand their rights, that communication needs and barriers must be considered, and that live links should not become the norm by default, and that they are not a replacement for in-person attendance. Part 4 of the bill is essentially technical or administrative in nature. While we considered each aspect, it is fair to say that our scrutiny of this part centred mainly on Clause 28, on the restriction of the role of the taxing master. We explored this in detail, but towards the end of our committee stage, we were advised of the Minister's intention that Clause 28 would no longer stand part of the bill, but instead the Minister would bring a new amendment relating to reform of taxation. We will discuss this more in detail later in this debate. And then there are further significant additional policy areas, including new serious organised crime offences, changes to the rehabilitation of offenders regime, provisions relating to restorative justice. Minister. Over the course of its scrutiny, the committee received oral evidence from 26 organisations or individuals, had 36 submissions in written form, commissioned 14 research papers and amendments, held 2 informal roundtable events, had multiple briefings from the Department of Justice, and received several legal briefings on the human rights implications and on the delegated powers in both the bill and the planned amendments. We deliberated over 8 meetings and agreed a report on the Justice Bill on the 26th of March 2026. In total, During the committee stage, we considered the bill and related issues at 51 meetings. I therefore thank the members of the committee, past and present, for their contribution to the robust and careful scrutiny of the bill and planned amendments. I also thank the organisations and individuals that provided written evidence and those who attended to provide oral evidence. Their contributions greatly assisted our scrutiny and will help inform the final shape of this bill. I also record the committee's thanks to the departmental officials with whom we had significant engagement through both oral evidence sessions and in written correspondence throughout the process. The committee also appreciates the support and assistance provided by Assembly staff, including the Bill Clerk, research officers, the Examiner of Statutory Rules, the Communications Office, Assembly Broadcasting, and the staff from Hansard, legal services, and all the others who all played an important role in supporting the committee to undertake its legislative scrutiny. Finally, I thank the committee team who supported the committee not just to complete the committee stage of the bill, but to handle all the rest of the normal business of the committee, which obviously must continue during the scrutiny of the bill. I now turn to the first group of amendments, Mr. Speaker. On behalf of the committee, I will speak first to the ministerial amendments in this group that the committee had sight of, and then to the committee's amendments. As I said, the committee was advised during an oral evidence session just before the bill's introduction that the department had identified the need to bring forward amendments to the biometrics section of the bill following stress testing of the provisions with operational partners. The committee was, understandably, slightly taken aback by this development, given that it came just days after the bill's introduction. The committee received the text of the planned amendments in late October 2024 and noted that the amendments made changes to Clause 1, Clause 3 and Schedule 2. It also introduced new clauses which we'll come to later. Clause 1 is the longest single section of this bill, extending to over 16 pages in the bill as introduced. It is therefore unsurprising that the committee heard extensive evidence on those provisions of the bill, from rights groups and advocates, academics, children's groups, victims groups, legal bodies, from the PSNI and other justice partners, and from the Scottish Biometrics Commissioner. There was significant support for the move away from an indefinite retention regime and for the introduction of a review mechanism for those who wish to challenge the retention of their biometric material. However, whilst the approach was welcomed, there were many questions asked about the rationale for the 75, 50 and 25-year model that had been selected. There were also questions raised about other aspects of the retention framework, particularly for children and for those who have not been convicted of any offence or who were arrested but not charged. Whilst the establishment of a biometrics commissioner was also largely welcomed, there were some questions about the independence of the commissioner and their role and their power. The committee sought clarification from the department on the precise factors used to determine the length of the retention periods. The department set out a range of factors that were taken into account in the development of the model, advising that it had settled on numbers that could be integrated into a model based on severity and age and provide for a graduated approach that was not overly complex to administer. We also discussed the proposed framework with the Scottish Biometrics Commissioner, who advised that biometric retention varies right across Europe, and in his view, nobody has the gold standard. He also pointed out that it is not indefinite retention that is wrong, but the indefinite retention of material with no prospect of review that is wrong. In the end, the committee recognised that whilst not perfect, The retention framework for DNA and fingerprints will strike a balance between protecting the rights of individuals with the need to protect the public and prevent crime. It should deliver a workable system that would not be hugely complex to administer and deliver. I'll now turn, Mr. Speaker, to the ministerial amendments numbers 4, 111, 118 and 119. The text of amendments 4, 111, 118 and 119 wasn't provided to the committee, but they give effect to a request made by the committee during our scrutiny. In the bill as introduced, Article 63E11 provided the power for the Department to amend the nomenclature of disposals specified in Article 6310, which includes references to a caution, an informal warning or restorative caution. Our scrutiny of the bill included scrutiny of the delegated powers in the bill. It was noted that the power at new Article 63E11 was a power to amend the primary legislation, commonly known in this place as Henry VIII power, though was subject to the negative resolution procedure. The Department advised that it considered the negative procedure to be an appropriate and proportionate control for this power. They considered that any amendment made by the power was limited and could only be change the disposals in order to keep pace with any changes in terminology. They explained that this would also be necessary as the disposals mentioned in Article 63E10 in the bill were not statutory disposals with fixed names but informal processes and could change in practice. However, the committee was not content with this position. As I've read, this is a Henry VIII power, and while narrow in focus, it relates to the regulation of biometric data, which is a matter of both significance and sensitivity. The committee therefore sought the Department's agreement to amend the power at new Article 63E11 to the draft affirmative procedure. I am therefore pleased that these amendments were tabled by the Minister to enable this change, and I thank the Minister for that. Ministerial Amendment 99 then, in Clause 310, the committee also noted during its consideration that the delegated powers, the rule-making power at Clause 310, was absent from the bill. The Department undertook to correct this at consideration stage as an amendment to Clause 31, and again I am pleased to see that this has been tabled by the Minister. Amendments 66, 67 and 126 introduces two new clauses and a new schedule. The committee heard from several respondents about concerns with proposed new clause 23A and new schedule 5, which introduces the power to photograph certain persons at a police station. Concerns were raised about the use of photos and whether they should be classed as biometric material and subject to the retention schedule. The Information Commissioner's Office, for example, stated that there needed to be further clarification as to whether the further technical processing of custody photos would render them as biometric material. I will address the question of photos further shortly, Mr. Speaker, when I come to the committee's first amendment. The Commissioner for Victims of Crime queried how these custody photos would interact with the release of custody images in instances of public interest or for reporting purposes, and whether their classification as biometric material might prevent their release. The committee understands that this is a matter for the Chief Constable and that a working group has been established to develop procedures to govern the release of images. The British Association of Social Workers stressed opposition to the amendments as they felt that the Article 63P of the bill would allow for a 5-year retention period for material taken from someone completing a community-based restorative justice scheme who was under 18. They felt it disproportionate to extend the provision to include custody photographs, which would be taken for such community orders. Amendment 67 introduces new clause 23B, which allows the police to stipulate a time and a date for an individual to attend a police station for fingerprinting. The committee had a written submission from the former Biometrics and Surveillance Camera Commissioner in England and Wales, who felt that the amendment was missing an opportunity. He said that consideration should have been given to also allow for taking of fingerprints or other biometric material at locations other than police stations, to allow for greater flexibility in the future. His view was noted by the Department and then by the committee. During the evidence gathering phase and in response to concerns raised, the committee sought the views of the PSNI on these proposals. In particular, the committee asked if it would constitute a new offence if a person missed an appointment to have material taken. The PSNI advised that it was their interpretation that failure to turn up to provide fingerprints and DNA is not an offence. The PSNI welcomed the amendments, which they advised would allow them to plan and allocate resources more efficiently. The committee heard that work is ongoing to determine how the provisions will work in practice, and that the PSNI expect that a level of flexibility will be afforded to an individual, but that this will depend on the operational environment and the resources available. Mr. Speaker, I mentioned that the committee did not have sight of all the amendments tabled by the Minister that are in this group. I have addressed some of those as they pertain to a consideration of specific issues that the committee did consider. The other amendments, 2, 3, 14, 17, 106, 107, 113 and 116. Amendments 120 and 126 have changes to the text of the versions that the committee did receive. Members noted these at the meeting on the 28th of May, but the committee did not have a position on them, and they are not included in the committee report. Otherwise, the committee are content with the other ministerial amendments in this group. And I now turn, Mr. Speaker, to the committee amendment number 40. Whilst the committee may have agreed that it was content with clauses 1 to 3 amended as proposed by the Minister, this is only because the committee agreed to bring forward an amendment to address what appeared to many to be a glaring gap in the bill. That is, the absence of other forms of identification of a person, such as photographs or images, from the retention framework. Many believed that the approach taken in the bill is limited, and that a broader definition of biometric material should have been included. The committee heard that in itself a photograph is not biometric data, but when a technical process is applied to use the photograph to identify someone, it becomes biometric data. There was also a recognition that biometric data will extend beyond photographs. Facial recognition and gait analysis are just two examples. It was argued that there was a need to try to future-proof the bill in order to keep up with emerging technologies. In the first instance, the committee sought to determine the rationale for the exclusion of photographs from the bill. The Department advised that the bill aimed to address compliance issues with the Police and Criminal Evidence Northern Ireland Order 1989 PACE, which relates to fingerprints and DNA only. The retention of photographs could not be considered separately from the use of photographs, and detailed policy development, engagement with stakeholders and the public consultation would be required before legislation could be brought. The Department also advised that work was ongoing in other parts of the UK on the retention and use of photographs, including the use of facial recognition, that they would wish to take account of this work in determining how to proceed here. We also discussed the absence of photographs with the PSNI. The committee heard that the PSNI policy is to treat facial images in the same way as fingerprints and DNA, and they will therefore be subject to the same retention regime even if they are not included in these provisions. Whilst the PSNI's treatment of photographs went some way to reassure the committee, members nonetheless remained concerned about the absence of photos from the bill, believing that it presented a significant gap in this legislation. We initially wrote to the Department indicating that we were actively considering an amendment to bring photographs within the scope of Part 1 of the bill, and formally asked if the Minister would bring forward such an amendment. In response, the Department reiterated its earlier position that making changes to the definition of biometric material beyond that already in the bill was substantive and complex, requiring detailed work and public consultation. However, it was suggested that the committee may wish to consider introducing a power to allow the Department to bring forward regulations for the retention and use of photographs after it has had the time to undertake the necessary work. The committee considered the approach proposed by the Department to be an acceptable compromise. Initially, we asked the Bill Clerk if such an amendment could be drafted not just for photographs, but in a way that might capture emerging technologies with the aim of future-proofing the bill. However, the committee was advised that the framework for the retention of material applies to those taken under the PACE order, and there were no current categories of biometric data within PACE that such a broad amendment could be linked to. The committee therefore agreed to bring forward Amendment 40, requiring the Department to make regulation about the retention, use and destruction of photographs. Before doing so, the Department must consult with representative justice partners and other public bodies who are representative of interests substantially affected by the proposals. The committee felt this was a necessary step to make sure any proposals were fit for purpose and made in conjunction with bodies who could best shape the regulations, such as the PSNI, the Human Rights Commission and the Information Commissioner. The Department must undertake further consultation on any changes to its proposals as a result of that initial consultation, and the summary of the consultation must accompany the draft regulations when laid. The regulations will be subject to the draft affirmative procedure and must be laid within 5 years, beginning on the day on which this bill completes all of its stages and receives royal assent. As I have said, the committee believes this amendment to be an acceptable compromise between what we heard in evidence and what we heard from the Department, and I trust the House will support the committee's amendment today. Committee Amendment number 104, commencement of Part 1. Clause 33(3) provides that the provisions of Part 1 of the bill will be brought into operation on the day appointed by the Department. Clause 33 is the commencement clause of this bill. One of the early pieces of work undertaken by this committee when the Assembly returned in 2024 was to undertake post-legislative scrutiny of acts made in the 2011 to 2016 and the 2017 to 22 mandates. As part of that work, the committee found a number of acts where provisions had not been commenced, and it has engaged with the Department on the reasons why not. Given our legislative programme, the committee has not been able to follow this work up, but I expect we will return to it in the future. However, I can say that the work helped shape members' consideration of the Justice Bill. Therefore, when the committee was determining the timescale within which the regulations under our amendment for the retention and use of photographs should be laid in the Assembly, we questioned why there was no specific timescale for the commencement of the provisions of Part 1 of this bill. Members felt it important that these provisions were commenced at the earliest opportunity, given that they deal with sensitive data and are necessary to comply with the European Court of Human Rights judgments in the Marper and Gawkin cases. The Department advised of the volume of complex work that would need to be done in preparation for the implementation of the new legislation. This includes a range of subordinate legislation and related consultations, and development and testing of software systems. In addition, the Home Office will be required to legislate for accepted matters before commencement. Whilst it was estimated that the new retention framework would not take place until 18 to 24 months after royal assent, this would be kept under review. Given the scale of the work required, some of which was outside its control, the Department considered that a statutory duty to commence the provisions would be problematic. However, the Department suggested that if the Committee wished to proceed with such an amendment, the day to be appointed should be within 5 years of royal assent. Members did express some concern at the proposed timescale of 5 years, believing that the DNA and fingerprint retention frameworks should be implemented at the earliest opportunity, as it is necessary to address human rights concerns. However, given the risks highlighted by the Department, the Committee agreed to bring forward Amendment 104 to require that Part 1 is commenced within 5 years of royal assent. Yes, I would, yeah.
And just to confirm that whilst many of the things that he's referenced won't fall to the Department in terms of our ability to actually influence the timing of them, we do believe, and we concur with the Committee, that the 5-year term is a reasonable period in which to do it. I would also want to reassure members that if it can be done sooner than 5 years, we will take that opportunity to do it.
I think the Minister for that intervention, it's really, really important that in this debate we can engage and confirm and clarify things, so I really appreciate the Minister's intervention in that, and I would hope that that should give succour to members of this House with regards to this amendment on the commencement of Part 1. And again, I would ask the members of this House to support those committee amendments. So I thank the Minister for that clarification, because it is really important that the committee sees work and progress being done in that 5 years, and I hope that the Department will work with partners in our justice system and beyond to ensure that those important provisions are commenced well before that 5-year period has elapsed. I do take into consideration what the Minister says to ensure that this is done in the appropriate and proper way, and so I hope that there's due diligence given to this commencement. Mr. Speaker, that ends my commentary as Chairperson of the Justice Committee, and I now wish to make remarks as DUP spokesperson for Justice on this part of the bill. Mr. Speaker, you will remember the second stage of this bill, where I coined and named this bill half a bill. Half a bill. And I was scathing. I was absolutely scathing. And this was before I was even committee chair. I think I was even in here just on bench duty, and I was so aggrieved that I wanted to speak. So I spoke at length about the Minister bringing half a bill to second reading. And why was I so alarmed? Well, quite simply, if you look at the depth and width of the amendments here today before us, you can actually see, if I was to take out all my guff from inside the actual bill, you can see that the amendments are actually thicker than the bill itself. So this is a very special day. Yes, I will, yes.
Would the member like to point out how many of those pages are amendments that he has tabled to the bill?
I thank the member and Minister for that intervention. Sorry? Yes, of course. I couldn't resist it, Mr. Speaker. And the Minister is quite right, because we have taken advantage. We have taken advantage of the licence given to us, provided by us, by the Minister with regards to this bill. But in all seriousness, it is really important that we scrutinise legislation in a proper fashion. And this is a very special day, because half a bill is meeting its partner, the other half of the bill. And so it is really important that at this stage, at consideration stage, that we're able and we're willing to scrutinise all the amendments. The Minister will know, and this Assembly will know, I love a good amendment. I love a good amendment. But this is the place to scrutinise it and to debate them. And I just wish we had been afforded that at second reading. So here we are with a bill, and not only that, Mr. Speaker, I would say that even the half a bill has went through a bit of an odyssey to get to here. I don't think Homer could have written this, because even the half a bill has been transformed as it's journeyed through the committee stage, with massive changes to Part 1. Now, the Minister brought those amendments very quickly to the committee so that we could actually get sight of them, but they had been stress tested after the bill had been tabled. And I think the stress testing should have been done before it was tabled. And I think that could have then meant that we wouldn't have had such a long period at committee, and we wouldn't have had to look at blue pages and white pages of amendments. So I don't think this is a very wise way to do legislation. And I hope that no other department, no other minister would try and bring a bill this way. Now, yes, I will, yeah.
Being very generous with his time, but I think we would all agree that the ideal situation would be the one, for example, with the sentencing bill, where the vast majority of the clauses are contained in the bill that is introduced at second reading. We were coming, obviously, out of a period of suspension of the institutions, which meant that we needed to act at pace, because this was always going to be quite a diverse piece of legislation, and therefore was going to require considerable scrutiny. And I suppose my priority was to ensure that this was able to get to this stage before we ended the mandate. And I obviously appreciate what the member has said with respect to assuring our amendments early, which we did to try and maximise committee scrutiny, because I want to be clear that I respect the role of committees in this House. I believe that the work of committees is vitally important in terms both of scrutiny, but also in terms of identifying areas where new policy can be developed. And whilst I would prefer that we were able to do that in slower time, perhaps in the next mandate, if we actually get a 5-year mandate, that will be how we proceed from there on.
I thank the Minister for that clarification, and I also thank the Minister for clarifying the changes that have been made at this point, which the committee had not had sight on, and I accept the explanation about the tidying up nature of those. I worried at the time when I read them last week that they changed policy in some way, but I'm glad that they don't change policy at this point. Going on then to Part 1 of this bill, Principal Deputy Speaker, there's absolutely no doubt about this. This is massive. To, first of all, comply with human rights, which we should do as a state when it comes to our personal data, I think is really, really important. But that must be balanced up with the duty that we place on our police force to protect us and to prevent crime, and also to catch criminals who commit crime in order to keep society safe. So this is really, really important stuff. And so it is right that the Minister looks for some structure as to how to do this. And the Minister has tackled this by going down what we've basically labelled as the 70-50-25-year model. And it is really complex. And when you read the bill and you read the sections of the bill that deals with this, then you get a really complicated picture of a sliding scale of offences, of age, and different scenarios, because they're not all offences, that comes into play. And so it is really, really complicated. And what I had to do at the very start was actually chart out on a piece of paper everything that the bill did and each clause. And 75 years would seem like an awful long time. It's a lifetime to hold somebody's personal data. But that is for people who have been convicted of a qualifying offence, the most serious offence in our land. And so I think it is appropriate, because we do have, from time to time, historic cases which need to be investigated, which could link certain crimes with other crimes. And that will bring truth to the victims, if not justice. And I think that's really important, that we give the PSNI the tools in this modern age of biometrics and digital world that actually helps us defeat crime. Yes, I will. Yeah.
Thank the member for giving way. And indeed, that was a key concern for me when reading this particular aspect of the bill. Would the member agree that there are many victims across Northern Ireland who would certainly be looking on with concern if there was a removal of fingerprints or other biometric details of individuals that potentially were connected to the murder of their loved ones?
Valid point, and the reason why I raised the victims in this, because it's really important that the police use modern technology to solve crime, to bring justice to victims, and to bring justice to society, and to bring justice to the culprits. And that's why it's really important. We then go down to 50 years where P is convicted of a recordable offence and is given a custodial sentence. There are differences here with regards to age. And I found it hard to get my head around why age would be a factor. Because if you're talking about the retention of an under 18-year-old's data, surely there could be an argument for saying that that data should be retained for longer, not less, because of their age and because of the fact they're going to live longer than most of us. But the Minister has fallen down on her structure, as she has suggested in the bill. And here's the thing. It's very hard, once there's a structure in place, to actually change the structure completely, to come up with a better model. Yes, I will, Gilbert.
Both members have said, just to reassure, there is a mechanism within this to ensure that where there is still an open or an unsolved case, that data can be retained. So the police will review their files every 5 years to make sure that the case is still open, and then we'll make a decision as to whether or not it's proportionate. And when it comes to the issue of the retention of data that the member is raising, particularly with respect to, for example, young children, the issue there is about proportionality. So, for example, if someone as a minor commits an offence and then goes on not to re-offend, that would be taken into account. But to be clear, that is a challenge that they take to the Commissioner, so they have the opportunity to request it. And I think that those checks and balances are carefully crafted in order to ensure that we do protect public safety, but that we also give people the opportunity where their data is no longer required to have it properly removed from the system, because I do think that we've already had a court judgment in terms of indefinite retention, which was also helpful in saying that one of the considerations we had to give in any new scheme was age of the person involved in the offending.
Yeah, that's a very important point that the Minister raised, because the appeal structure shouldn't just be one way. Should be both ways. So if someone has their data retained and they feel that they shouldn't have it retained, or their family feels that they shouldn't have it retained, then I think there should be procedures in place where that can be scrutinised and processed, both within the PSNI, who the Minister quite rightly says retains this data and controls this data, but then they have that independent body with regards to the Commission in this case, where they can then appeal to. We go on down through the years, 25 years for when P is convicted of a recordable offence but is not giving a custodial sentence. And there are other areas, under 18, not given a custodial sentence of 5 years or more, where P has completed the combined restorative justice process and the offence is recordable. So you can actually see how the structure cascades down and then the years drop. If P is given a custodial sentence of less than 5 years and the offence is the first offence and is under 18, then that is the length of the sentence plus 5 years. Very complicated, but I can understand the logic. And in 5 years, if P is under 18 and is convicted of a recordable offence and it's P's first offence, So you can understand why we're doing this for first offence. Sometimes, especially young people, they make mistakes. And they have to pay for those mistakes. Justice must be seen to be done. Victims need justice served. But there is that exemption and that exception for first offences. And I actually like that idea. And then we go down to 3 years, where P is arrested for a qualifying offence or is charged with any qualifying offence but not convicted. And I think sometimes you can get more controversial here in these lower years. P is charged with a recordable offence, again 12 months, 2 years if P is given a penalty notice under Section 60 of the Justice Act 2011. So when I first read that, Principal Deputy Speaker, I thought, a penalty notice? Really? Are we getting DNA collected for penalty notices? But as the Minister has already pointed out, it's not a penalty notice like a driving offence. It's not that type of penalty notice. It actually falls under Section 60 of the Justice Act, which, as the Minister has recited, includes indecent behaviour, shoplifting, theft, criminal damage. I think drunk in a public place maybe is in that too. And the Minister didn't add that when she listed them out. Disorderly behaviour, behaviour likely to cause a breach of the peace, and then where it is alleged that the accused resisted, obstructed or impeded a constable. So, even though if P is guilty of a penalty a notice under Section 60 of the Justice Act 2011, they are quite serious offences. And so that DNA, that biometrics material, can be retained for 2 years. And then, as the Minister has outlined, there are times when the Chief Constable can then apply to have that biometrics material kept for longer. And then, of course, that's... Yes, I will, yeah.
Also agree with me that the term breach of the peace is a pretty wide definition. As somebody who was previously in a court case for protesting peacefully, it was classed as a breach of the peace, and there's obviously more serious elements of breach of the peace. We'd be concerned that that sort of quite loose a term could be used to keep people's data for quite a long length of time, and by most people's definition, the person may or may not have actually been involved in a serious crime. Do you have any concerns in that regard?
Yes, I do. And I thank the member for his intervention, because I do have concerns around that. But I think if crime has been committed, no matter how light touch that may seem to some members, I do think the fact that this scale, this sliding scale, I think actually appreciates that and actually acknowledges that. And I do think that I like the idea of the Chief Constable, who is the holder of this data, who is also tasked to investigate and solve crime. I think it's right that they would have that tool, that flexibility to apply to have DNA material retention extended, because there would need to be good cause. There would need to be good cause from the Chief Constable to actually apply for retention of that data beyond the scope of this structure. So if there is good cause and it's coming from the Chief Constable, I think it's right and proper that that would be attested and that would be assessed, and then a decision would be taken as to whether and of course there's a court setting in this too. There's a process with regards court. So I do think that when you look at the structure that the Justice Minister has produced, and you could come up with all sorts of various structures, and we'll come on to that in a wee minute, I think that this is basically where the Minister fell down. I think this is what she agreed on. I think that's what her department is comfortable with. And I think for an Assembly to mess about with that too much at this point could be putting the bill, Part 1, in jeopardy, and also tying the hands of the PSNI and all other criminal justice organisations with regards investigating crime, solving crime, putting culprits behind bars, and also making sure that they have all the information they require on anyone who has breached the law. Where I do have an issue with, and I'll come on to explain why, is whenever someone hasn't been convicted of a crime. When someone hasn't been convicted of a crime, they are innocent. But there are parts of this structure that allows for the retention of their DNA. Now, when you think about that, and you think about sometimes how a court case works, and sometimes people can get off on technicalities. Sometimes people can get off because there's a flawed investigative process. Sometimes people can get off because they haven't been asked the right questions at the right time in custody. And so I do believe that it is appropriate then that DNA would be retained for a period of time, even in cases like that, because it builds up a knowledge base and intelligence level for the PSNI to investigate crime further, and then also in other parts and arts of the country whereby you might have a single culprit. So I do think that the Minister's structure is a sound one. We could all pick holes in it, and we all come up with our own ideas with regards to biometrics retention. But I do think that when the Minister and the Department has decided on a structure, that we have to assess it, we have to scrutinise it, and then when we come down one way or the other, we have to say, right, okay, this is the way it's going to be. Yes, I will, yeah.
Forgiven way, but just in relation to the point that you've just made, would you have concerns relating to the fact that the Law Society and other human rights advisors have told us very clearly that the ability to retain someone's data after they've been acquitted is potentially in breach of Article 8 of the Human Rights Commission?
Yeah, so I would have concerns around all of that, as we had took evidence around that, but that's for the Minister to answer on her structure and her operation of her structure and the bills that she has produced. And I think that this isn't perfect. I think that there are cases of concern, areas of concern, but the challenge, I think then, and I'll come on to Sinn Féin's amendment soon, I think the challenge there is, how do you produce something that's similar or better than the Department, in connection and in communication with the PSNI? How could you come up with something better that will strike the balance between human rights compliance and also detection and investigation and solving of crime? So I do think there's a balance here. It won't be a perfect balance. We won't get it right. The Minister won't get it right. The Department won't get it right. But I think we have a framework in place that we'll have to go with. There's no other show in town. And I think that that's why it's important that these things should be reviewed to ensure that they're fit for purpose and that they're affording people justice, they're affording people protection, and they are human rights compliant, which is the whole case of the bill. Yeah.
I appreciate you doing so. But I think, and the earlier comments that you made sort of go to the heart of this. So we have to balance human rights compliance. We have to balance the ability of the judiciary and the police service to carry out their function. We also have to remember that the assumption of innocence is paramount in all of this. And the member for West Belfast previously made reference to maybe someone being charged with a very minor crime as a result of being present at a protest, for example. And if someone in that situation is then presumed to be capable of further crime, even though that person is not someone that would be ordinarily involved in crime, are we setting a dangerous precedent or putting a theory in the police's mind that this is the first cohort you go to that are likely to be involved in crime, when in fact that portion of people are not at all?
I thank the member for her contributions, because she raises very valid points. But I think the fact that the PSNI can retain biometrics data in this regard means that because the police hold your biometrics data, it is not an admission of guilt. So there'll be data in there, in the storage, from innocent people. So there should be no. Minister wants to get right? Yeah.
The holding of biometric data is not a presumption of guilt or a presumption that somebody is likely to offend further. The holding of biometric data is a tool to allow the PSNI to thoroughly investigate crime as it occurs. It doesn't limit the cohort of people that they will investigate to those who already have data on the system, but it does allow them to, for example, take fingerprints and compare them with the databases they already have, which may help them either eliminate people from their inquiries or indeed identify people who need further investigation. And the key for me is that it has to be proportionate, which is why we have put this structure in place to ensure that there is not indefinite retention, that there is a proper scheme depending on the seriousness of the offence that's committed and also the age of the offender. And that people have a right to appeal in order to have their data removed if they feel it is disproportionate for it to be held, and that will be considered by an independent biometrics commissioner. So those are the checks and balances around this. So it's not about a presumption of guilt or a presumption that people will go on to reoffend. There will be many people who have data on the police database that will never reoffend. Equally, there will be people who reoffend and don't have any data on the database. So what we need to try to do is just give the police the opportunity to be able to search the information they already have through people who have known convictions and then eliminate or include them within their inquiries.
I thank the Minister for that important intervention. I hope that goes some way to clarify and assuage the concerns of the members opposite in this regard. And I suppose what I would say to this is we're in an age now where if you travel, yes, yeah.
We're being given ways before I came this time, and I mean this in the most genuine way, because I remember on the Health Committee, the members expressed some concerns about COVID vaccines and different sort of issues, and it's not wholly disconnected, because that's about the storing and the presentation of data. But the members may be going through a bit of a conversion on chair of the committee, because this is a whole lot of data. We're consenting and being okay. I'm not, but other members are seeing to be okay for the PSNI, the police service, to hold this amount of data of people. Does he not have any serious concerns about that? Because I'm not really hearing it with respect from him.
He was right with regards to my concerns around the Coronavirus Act and what it did to our people. And I am totally and utterly opposed to a digital ID. But the reason why I'm opposed to those measures is how our data would and could be used, not necessarily the retention of that data. So we have been getting fingerprints for ages. Whenever the police have investigated crime, when they have arrested someone, they have always taken fingerprints. And so DNA or biometrics is that, but it's retained by the PSNI. Now you could argue that's the state, but it's then how that data is used. So if the Minister was coming here with a structure that said anybody who is in the PSNI database can't go to concerts, can't obtain everyday living accommodation, can't get a job, can't travel, can't do all the things, all the freedoms that we enjoy, then that's where I have a problem. And I'm right to have a problem. Yeah, so, Minister.
Just provide clarity, because it was also discussed earlier about people who have been acquitted and their data being retained. If someone is acquitted, in order to comply with human rights, their data has to be removed from the database. And if the police wish to retain it, they have to apply to the Biometrics Commissioner and have independent assessment. So this is not a kind of catch-all where the police can simply collect data and keep it. In fact, the evidence shows that if they thin their data, they're more likely to get information from it and be able to find it, because otherwise you can't see the wood for the trees. With respect to the members' concerns about people's private data, I share those concerns. I don't want the police or any other organisation to have unfettered access to my data and to be able to use that for any purpose, which is the point of these biometrics regulations, is to ensure that that is not the case. Of course, there are legitimate purposes for people to hold our personal data and our biometric data, and those are legitimate and fair, but they also have to be proportionate and respect people's right to a private life and respect people's privacy and dignity. And so it's important that that balance is struck. Members may well argue about whether that balance has been struck in the right place, and I'll come back to that in my closing remarks on this group. But I do think it's important to say that none of us in this chamber would wish to see unfettered access to people's data and the ability to retain things indefinitely, which is unfortunately the situation that precedes this bill being passed.
Yes, I will. Yeah.
Thank the member. And I mean, this is an important topic, and of course, in the bill there are a range of timescales. At the bottom end, 2 years, 3 years, 5 years, and going right up for serious convictions, 25, 50, 75 years for recordable offences and the most serious ones. So it is on a scale, and it is not uniform. And for those who are arrested for a qualifying offence but not charged, or those who are charged but not convicted, it is at the bottom end of the scale. It is 2 or 3 years. And does the member acknowledge that during an investigation, information can come to light? It doesn't all necessarily be available to the police at the start, and it is sensible for DNA data for someone who has been arrested, who was a suspect, or if they've been charged but not convicted, just to allow a period of time in case something else comes to light during that investigation.
Contribution, as with the Minister and with Jerry Carroll also, their interventions. This is a really serious topic, and so we need to take this very, very seriously. But we also start with the base that this is us trying to be human rights compliant in the first instance. That's our base. That's what we're trying to do here. That's the motives behind this bill. So it's really important. And of course, whilst the Coronavirus Act is in this bill, and so we could and should talk about it with regards to live links, the issue around the Coronavirus Act, what it did to our people was awful. And the stigma and the harm that was caused by the use of those regulations will be with us for decades. Decades, including our children who won't now and can't now go to school and all of that.
Order. Nice try, Paul. So, the Coronavirus Act, as you say, is related to live links. I've read the bill as well. So can we return that aspect to the bill, please? Thank you.
Principal Deputy Speaker. But the point that the member across the way raised, Emma Sheeran, is a really important one. So, about the data collection and innocence. And the question of innocence should come into it. And that's why this structure must have those safeguards where you can repeal or ask for an appeal, to have that removed. But I would say to the member, we now live in an age where if you want to travel, you must go to the airport and put your palm of your hand on an electronic pad in order to get it aligned with your photograph on your passport in order for you to travel through countries. I don't necessarily like that, nor am I comfortable with that, but that is the state of play. Yes, I will.
Would the member also agree that that's somewhat voluntary, because people don't have to travel by airplane, whereas this data we're talking about is being held in many cases without people's consent? So there's a bit of similarity, but also it's a bit like apples and pears slightly.
There's two issues there. The choice issue, it's not really a choice for someone not to travel. That's like saying it's your choice whether you want to work or not. It's your choice whether you want to go to that pub or not. It's that choice whether you want to go to that restaurant or not. And that's why I would be totally opposed to data being used in that way. The other point is rights, the point about human rights. But we have to be allowing, when someone commits a crime, that there's a diminishing of their rights, their right to freedom, if they're incarcerated, if they've got a custodial sentence. So there are qualifying aspects to all human rights, and this is just one part of it. So this is a really in-depth, good debate on these serious matters. And it's right for us to have this debate because we are trying to be human rights compliant. And that's the most important thing. Yes, I will. Give way.
First instance, the member can invoke his right as someone born in the island of Ireland to have an Irish passport and not have to go through that process. But just secondly, and the Minister made reference to the fact application to the Biometrics Commissioner, and I'll talk in more detail about our concerns about that, because there are worries there about the independence of such person who is ultimately still answerable to the PSNI. So the concern here is that there is a presumption that someone was arrested and therefore is more likely to have committed another crime, and that's I suppose what the proportionality element that we're worried about.
Yeah, and it's that balance that we have to strike between giving the police the powers to actually solve crime and bring criminals to justice, perpetrators to justice. That is the balance. This is what we are going to be debating and arguing about in this part one. But somewhere along the line we must fall down on what the structure should be. And that's why I think it's important that the department have this structure in place. It's contained within their bill. They have changed it in many ways, but that's basically where they have fell down. And agreed? Yeah, I will.
Would the member agree with me that, for example, if somebody is released without charge during the course of an investigation and their data is immediately removed from the police database and they go on to commit further serious offending, that would be seen as a failure on behalf of the PSNI in terms of their investigatory processes, and therefore there have to be checks and balances. If somebody's data is collected, it is right that it should be removed at the point where their guilt or innocence has been established in a proportionate way. But to simply, because someone has not been charged with an offence, to say that you would remove their data from the database would potentially hamper police investigations, where they would not be able to follow up with people who are persons of interest, or indeed either for that particular crime or for others. And we have had complaints raised where, for example, things like fingerprint data has not been immediately accessible, and that has led to problems with investigations. So this is about trying to find a balance so that it is retained for as long as is reasonable, but no longer, and that people have a right, once their innocence is established, to have it removed from the database at that appropriate point. And the members are of course right, there will be a period for every person when their data might be held and they haven't been convicted and they haven't been charged with an offence, but that's called the investigation phase. And there is also, there are measures in this bill that deal with the investigation phase that require the PSNI for long-running investigations to return and seek permission to continue to hold that data from the Commissioner.
For that intervention. I feel like I'm an intermediary here between Sinn Féin and the Minister. So I will make progress now, and I will talk to Sinn Féin's amendments. Now, it's for Sinn Féin to try and sell their amendments to this House, and so I will listen attentively when they speak to them. But what I can see and what I think I see, because it's really, really hard to look at the amendments, what they omit from the bill, try and work out the structure of the bill with the structure of the biometrics structure, and then try and work out what Sinn Féin is actually trying to achieve. Now, they will have time to tell us about that, so I won't need an intervention with that regard. But if I've got it right, you, Sinn Féin, are trying to say that where P is over 18 and convicted of a qualifying offence, or where P has completed the community-based restorative justice piece, and the offence is a qualifying offence, that would still retain and be kept for the 75 years. The difference with Sinn Féin's amendments, as I see it, is that where P is under 18 and convicted of a qualifying offence, or P is convicted of a recordable offence, and a non-qualifying offence, because there are the differences in offences, that means that data will only be retained for 3 years, if I'm right, or unless the Chief Constable applies an extension, or applies for an extension for a further 2 years, and then also a further 2 years after that, which in my mind, if I've read it right, means that for someone under 18 who's convicted of a qualifying offence, remember some of the most serious offences on our statute book, that data, that biometrics data, will only be able to retain for the most 7 years. I may be wrong there, but I'll certainly listen very attentively. 50 years, your data can be retained where P is convicted of a recordable offence other than a qualifying offence, and if P is aged 18 or over and is given a custodial sentence. So you can see the difference between the 75 years and the 50 years for the qualifying offence and the recordable offence, if I'm right, and then 25 years where P is convicted of a recordable offence but not giving a custodial sentence. So that's 25 years. If I can see anything other than that, please, I'll listen very intently to the contributions from Sinn Féin members, but it seems to me that you've struck out everything of 5 years, 3 years and 2 years, and of course one of your amendments does away with the penalty notice itself. And I suppose what I would say is this: why would you not retain DNA or biometrics data for someone who's been convicted of indecent behaviour, of shoplifting, of criminal damage, of being drunk in a public place, of disorderly behaviour, of behaviour likely to cause a breach of the peace, and where it is alleged that the accused resisted, obstructed or impeded a police officer? Why would you not then retain that DNA, even for a small period of time? And then that probably makes a mockery of the police then requiring people to come to the police station in order to have their biometrics taken. Another issue with Sinn Féin's amendments, and they can speak to them themselves, and we'll make judgment on that, is the fact that they seem to have stripped away any control that the PSNI have other than actually holding it. They don't have any sort of control with regards to appeals. They don't have any sort of control around assessments. And Sinn Féin don't even want the PSNI about the place when it comes to assessing these things. And I just think the PSNI, who are there to keep us safe, who are to investigate and solve crime, and who are the holders of this material, should have a part to play. They must have a part to play. And so I would worry about Sinn Féin's amendments and how it alters the structure that the Justice Minister has created. And I look to Jerry Carroll and I can see exactly why he has put this down. I understand it. I understand why he would put it down, and I will get it to speak to it properly. And I can understand why he has put this down, because exactly some of the views that I would have. But I suppose where I worry about this is, should it be on the face of a bill? Should it be in the face of this bill? Or should it be in pace codes? Should it be an operation? I don't know the answer to that. Maybe the Minister does. And so I maybe think if the Minister was to wind, she might give us some information around that. I can understand the checks and balances that Jerry Carroll is trying to create. I really do. So I would like to see a lot of that good stuff in somewhere. But the question I have, should it be in the face of a blue bill, or should it be in operational pace codes? So I await. I hold further, if you like, my reservations on that till we hear from the Minister or from anybody who can give us clarification on that. And of course the member will be speaking to it himself, I'm sure, and he can maybe clarify that point too, as it's his amendment. Yes, I will. Yeah.
Just to reiterate, there are two elements of concern with what has been proposed by Jerry today. The first is about national security determinations, and those are a matter for the UK government and don't fall within our purview as reserved matters. So that's the first issue, and it would fall outside the legislative. So 2C of Amendment 30, it would fall outside our legislative competence. So that's one thing. The other amendment, the member is correct in saying, are within the legislative competence of the Assembly, but we would argue that they would be better addressed through updates to Pace Code D, which will then be subject to public consultation, and that revised code will be introduced alongside the new retention framework. So it isn't, if you like, a blanket opposition to the intent, but the bits that are reserved matters we can't legislate on. The bits that aren't reserved matters, there are better ways of doing it. So it's not a complete blanket disagreement.
Okay, thank you, Minister, for that. And I suppose that's basically where I'm at, Mr. Jerry Carroll, with regards to your amendment, and I'm grateful of that clarification from the Minister. Principal Deputy Speaker, I don't really want to take up any more time on the Assembly's time with regards to that, other than just to plead with the Assembly to consider the committee's amendments in this group. I think they're sensible, I think they're reasonable, I think they add something to this bill with regards to the human rights compliance and also the protections for people. And I really worry about future-proofing the bill and then making sure that we can somehow encapsulate photographs which will come into play later on in our lives with regards to facial recognition and other technologies that come in that the state will use to detect people of interest. And so I do believe at that point that's where you would have to worry about what the state has and what it doesn't have, and how then it should retain it and destroy it. I think photographs are really important. The committee thought photographs were really important. My party thinks photographs are really important, and I would ask the House to approve those committee amendments, and also that the Minister would take them to heart and try and adopt them and commence them as soon as possible. Thank you very much.
Thank you, Paul. I call Patsy McGlone.
Thank you, Madam Principal Deputy Speaker, and my thanks to the Minister and to the members of the committee too.
Important milestone in what has been a lengthy process of scrutiny, engagement and development. It has in truth been a long time coming, and the Chairperson has outlined the long and windy path to get to this point. The Committee for Justice has spent a considerable period examining the provisions of the bill, taking evidence from a wide range of stakeholders, experts, representative bodies and rights organisations. That scrutiny has undoubtedly strengthened the legislation which is before us today, and I thank all those who have produced and put the effort into providing us with amendments. It is also fair to say that the committee expressed concerns regarding the scale of the amendment package brought forward by the Minister at this stage of the bill's passage, and while members will no doubt recognise the reasons why amendments sometimes become necessary, it is not generally the most effective way to develop legislation. Significant policy proposals are best brought forward at the earliest opportunity, allowing sufficient time for detailed scrutiny, stakeholder engagement and public consultation and consideration. This is particularly true in the case of a bill as substantial as this one. The Justice Bill touches on a wide range of issues across our justice system. It seeks to modernise aspects of policing and criminal justice, update legislative frameworks that have become outdated, strengthen the very protections for victims and improves the operation of the law in a number of important areas. The amendments before us in Group 1 deal with one of the most significant and sensitive elements of the bill, the retention, use and oversight of biometric material. As technology continues to evolve, biometric information plays an increasingly important role in modern policing. DNA profiles, fingerprints and photographs can be an invaluable tool in preventing and detecting crime, identifying offenders and protecting the public. Few would dispute the importance of ensuring that law enforcement agencies have access to effective tools to keep communities safe. However, the retention of biometric information also raises important questions about privacy, proportionality and individual rights. Decisions about how it is collected, how long it is retained and who can access it engage fundamental questions about the relationship between the individual and the state. The challenge before us, therefore, is not whether there should be a biometric retention regime. It is how we create a regime that is effective in supporting law enforcement while remaining proportionate, accountable and rights compliant. That challenge featured prominently throughout the committee's scrutiny. Excuse me. The committee received extensive evidence from policing bodies, children's organisations, rights groups, legal representatives and regulatory bodies. While there was in fact broad support for placing the biometric retention framework on a modern statutory footing and for the establishment of a dedicated biometrics commissioner, a number of concerns were consistently raised regarding proportionality, oversight, transparency and review mechanisms. Particular concerns were expressed regarding the treatment of children and young people within the proposed framework. Organisations including INICCY and others questioned whether sufficient distinction had been drawn between adults and young people. Concerns were raised regarding privacy, the presumption of innocence and the potential for stigmatisation where biometric information may continue to be retained despite an individual not being charged or convicted. Questions were also raised regarding the retention of biometric material following cautions, diversionary disposals and restorative justice processes, with stakeholders highlighting the importance of rehabilitation and reintegration within the youth justice system. The committee also heard differing views regarding the powers and scope of the proposed Biometrics Commissioner. While there is broad support for establishment of the office, questions were raised regarding the extent of the Commissioner's powers, the operation of review mechanisms, and I hope to hear a wee bit more about this, and the importance of ensuring meaningful independent oversight. Those themes are reflected in the amendments before us here today. During scrutiny, members also heard and benefited from evidence from the Scottish Biometrics Commissioner, whose contribution helped inform much of the discussion around both the ministerial and non-ministerial amendments before us here today. A recurring theme of that evidence was the effective biometrics regime is not simply about determining what information may be retained. It's about ensuring that any framework built upon principles of necessity, proportionality, transparency, independent oversight and public confidence. Those are key elements of any biometrics commissioner. The Commissioner emphasised the importance of creating systems that are capable of evolving alongside technology, which, as we know, is ever evolving, and ensuring that individuals understand their rights and have meaningful avenues through which decisions can be reviewed and challenged. Those principles can be seen through many of the amendments before us here today. Indeed, many of those principles are reflected in amendments brought forward by the committee itself. Throughout its scrutiny, the committee repeatedly returned to questions of independent oversight, effective review mechanisms, transparency, public confidence, and ensuring that individuals are able to understand and exercise their rights. And the SDLP stands solidly behind those key principles. The committee's amendments on custody photographs and commencement reflect those concerns directly, while a number of the wider non-ministerial amendments seek to give legislative effect to many of the issues identified through committee sessions. While members may focus on the differences between the Minister's amendments and those proposed by my colleague here, Emma Sheeran, it is important to acknowledge that both approaches are attempting basically to achieve the same overarching objective. Both seek to establish a modern, fit-for-purpose biometric framework capable of supporting law enforcement and public protection while ensuring that appropriate safeguards for individuals whose biometric information is collected and retained. Indeed, many of the amendments are mutually exclusive precisely because they seek to answer the same policy questions in different ways. The Minister's amendments have clearly taken on board a significant number of the issues raised. They strengthen oversight arrangements, establish the role of the Biometrics Commissioner, and place the framework on a clearer statutory footing than was originally proposed. However, the non-ministerial amendments seek to go further in a number of areas that stakeholders repeatedly highlighted during evidence sessions. In particular, they place greater emphasis on independent review mechanisms, rights of appeal, access to information, the treatment of children and young people, and the circumstances in which biometric information should continue to be retained following diversionary or restorative justice outcomes. Many of those proposals also reflect concerns repeatedly identified by the committee itself during scrutiny. Questions of accountability, transparency, and the ability of individuals to challenge decisions relating to the retention of their biometric information features prominently, and indeed the SDLP stands by those priorities. The argument being advanced by those amendments is not that biometrics have no role in modern policing. Rather, it is that public confidence is in fact strengthened where individuals have clear rights, where decisions are subject to effective challenge and review, and where particular care is taken in relation to children and young people. Those are very important considerations for the SDLP, and I'm sure members will share those. The balance is most clearly illustrated in the debate around children and young people. A number of the amendments before us seek to create a more differentiated approach to the retention of biometric material where those are under 18 are concerned. They reflect concerns raised by members during the committee scrutiny that children should not simply be treated as adults within the justice system, and that particular weight should be attached to rehabilitation and reintegration. Several stakeholders questioned whether biometric material should continue to be retained following cautions, diversionary youth conferences and restorative justice processes. The arguments were that where the justice system has deliberately chosen a diversionary route, consideration must be given to whether the continued retention of biometric information is consistent with the objectives of that approach. Yes, certainly, Minister.
I thank the member for giving way, and I too understand the importance, and he will be aware that I am committed to ensure that insofar as is possible we remove young people from the criminal justice system at a young age, in order that we can provide alternative ways of holding them accountable for their conduct and behaviour, but also ways that are more effective in terms of outcomes in later life. The difficulty, and I will no doubt get the opportunity to set this out when Sinn Féin come to discuss their proposals, is that, for example, the proposed new article at 63JA, Amendment 12, introduces a 3-year retention period for individuals under 18 who are convicted of a qualifying offence, and a 3-year retention period of a non-qualifying offence. So it doesn't actually differentiate between the two. That hasn't been developed or tested, but furthermore, it would remove Articles 63L, 63M and 63O in Amendment 13, and that would actually take away the less stringent regime that we have put in place specifically to deal with people who are under 18. So whilst the intent may be well-intentioned, I am concerned that it would dismantle some of the protections that the Department has drafted into these biometrics for young people.
Thank you for that, Minister, and you probably preempted what I was going to say next, but I look forward to hearing these matters teased out later on whenever Emma Sheeran presents the amendments there, so I look forward to that. And in fact, the amendments tabled by Emma seek to address those concerns by creating a more distinct regime for children. So I look forward to hearing that been teased out in some more detail later on. Rather than removing retention powers in these circumstances, the Minister's amendments seek to retain, now this is my view at the moment, Minister, so we'll hear this all teased out, seek to retain the ability to hold biometric information where considered necessary, while introducing greater oversight through the Biometrics Commissioner and a more structured statutory framework. Alongside the debate around... yes, sure.
For intervening again, but you mentioned about more oversight of the Commissioner. The purpose of the Commissioner is to be entirely independent in the judgments that they make. So what we need to do is create the Commissioner, allow them to bring forward in terms of the kind of guardrails around this, but to be independent of government. It would be inappropriate, I think, for us to try to control the Commissioner or limit or fetter their independence and discretion, because that would effectively mean us taking decisions on individual outcomes rather than leaving it for the Commissioner, who will be appropriately skilled to be able to do that. And certainly that is the way it has been done in Scotland and other places.
I understand that. I don't think anyone in the chamber here would suggest for 1 second that the Commissioner should be fettered in any way in his or her role. It's the function and the role of that Commissioner to let them get on with their job, basically, and make sure that those key principles of transparency, oversight and justice are adhered to within the functionary role that the Commissioner will have, and I thank the Minister for that. During committee scrutiny, concerns were raised not simply about what information could be retained, but about whether individuals would understand their rights, have access to clear information and be able to challenge decisions made about the biometric material. Excuse me. That's reflected in amendments dealing with review mechanisms, appeals, the provision of information and guidance, and the independence of decision-making. These amendments recognise the important principle that rights are only meaningful if people are aware of them and able to exercise them in principle. A framework that allows people to understand why their information is being retained, to seek a review of that decision and to challenge it through an independent process is likely to command greater public confidence than one that does not. There is one further area where scrutiny has been particularly important, namely the treatment of photographs within the new framework. The Department has made it clear that its intention is largely to bring Northern Ireland into line with existing legislative arrangements elsewhere. However, throughout scrutiny, a number of members questioned whether that approach risks missing an opportunity to address an emerging issue now rather than waiting for developments in other jurisdictions. The committee repeatedly sought clarification from both the Department and the PSNI regarding the treatment of photographs and images. Concerns were raised that in the era of facial recognition technology, increasingly sophisticated image analysis and rapidly developing artificial intelligence systems, photographs can no longer be simply viewed as ordinary images. The ability to extract biometric information from photographs is growing rapidly, and the law must keep pace with that reality. Ultimately, the committee and members were sufficiently concerned to bring forward the committee amendment creating a statutory framework governing the retention, use and destruction of custody photographs. That amendment reflects a view expressed by stakeholders during scrutiny, namely that the advances that I've already outlined in facial recognition technology and AI mean that photographs can no longer be treated as wholly and solely separate from the wider biometrics debate. We certainly believe in the SDLP there's merit in that approach. If we're legislation for the retention of biometric material, it is reasonable to ask whether photographs and images should sit outside the framework altogether. Similarly, we welcome the committee's amendment requiring commencement of the new framework within a specified period. The committee itself was right to highlight that legislative reform alone isn't enough. Public confidence will ultimately depend on these provisions being implemented in practice and within a reasonable time frame. There is little value in undertaking substantial reform only for the implementation of it to remain uncertain. If the Assembly concludes that these changes are necessary, then there should also be a clear, time-based pathway to their delivery. Reasonable people may disagree on where the balance should be struck. There is a legitimate public interest in making sure that law enforcement agencies retain the tools necessary to investigate crime and protect the public. Equally, there is a legitimate concern that children should not carry the consequences of contact with the justice system further than is necessary and something which is proportionate. It is our view the most important test is whether the framework that emerges properly reflects itself, the distinct position of children, provides meaningful oversight and review mechanisms, and commands public confidence that these powers will be exercised fairly, proportionately, and only where justified. For the SDLP, there are a number of important principles that should guide the consideration of this group. First, any biometric regime must command public confidence. That confidence depends not only on effectiveness within the system, but on public trust that powers are being exercised fairly and proportionately. Secondly, independent oversight is essential. Where the state is collecting and retaining highly personal information, there must be meaningful safeguards, transparency and accountability. Thirdly, individuals must be able to understand and challenge decisions affecting them. Rights are only meaningful if people are able to exercise them in practice. Clear information, accessible review mechanisms and effective routes of appeal are therefore vital components of any system. Finally, we must recognise that the particular position of children and young people that must be assessed and evaluated properly. Rehabilitation and public protection are not mutually exclusive objectives. Indeed, in many cases, successful rehabilitation is itself one of the strongest forms of public protection. Afrio Lashkan Corlia, the task before the House today is to ensure that the framework emerging from this bill itself strikes the correct balance between public safety and individual rights, between effective law enforcement and proportionality, and between accountability and operational effectiveness. These are the principles against which the SDLP will vote on successive amendments.
Patsy, thank you. Emma, Sharon, you're next. Emma, I'm going to have to suspend for the Business Committee at 1, so it's just to say I may have to interrupt your speech. Hopefully not.
Hopefully I'll be finished. Guru Magat, Priya, Lash, Concordia, and I want to thank everybody that has already contributed to this today and welcome the consideration stage of the Justice Bill, and I want to commend the work of the Minister, the Department, the Committee, including my party colleagues who were on the committee before I was, Deirdre Hargey, who previously was in the Chamber and served as the Vice Chair before me and did a brilliant job and has been a great support to me since I came on to the committee in trying to explain the context of a lot of this. And I also want to thank the Bills Office and everybody that's been helpful there in terms of getting our amendments before the House. So obviously we're discussing Group 1 amendments relating to biometric data retention and police photographs, and we in Sinn Féin have brought a number of amendments forward today which I want to speak to in the first instance: 5, 11, 12, 13, 23, 24, 28, 29, 32, 34 and 35, and I think it's important that we set out the context for these. We know that a new legislative framework to handle biometric data retention is necessary because of two legal challenges that resulted in judgments at the European Court of Human Rights, which found that our existing data retention framework infringed on people's rights. Indefinite retention periods and the absence of a meaningful review process were identified as key problems there, and that's what led to this. And I welcome that the Minister sought to remedy these human rights infringements under this new framework, and human rights were at the forefront of our minds when we sought to amend the work that is before the House today. And I want to place on record my thanks to our comrades upstairs in the policy team and the human rights fraternity who have given us such assistance in identifying gaps and how we could seek to improve things. We need to strike the correct balance. On one hand, we want to ensure that our criminal justice system has access to modern tools that can help keep people safe and bring offenders to justice, but we also must recognise that biometric data is highly personal. It belongs to people, not to the state, and that its collection, use and retention must be subject to appropriate safeguards. We need to have trust from the public in a biometric framework that works, but that has proper checks and balances to prevent overreach. And I welcome the proposals for a new biometrics commissioner, but I do question, and we have questioned throughout the committee, whether or not that commissioner has the necessary independence and the powers to adjudicate when there are disputes over police decisions to retain data. We also carefully examined how biometric retention frameworks were developed and rolled out in other jurisdictions, and I think we learned some valuable lessons there. So, in terms of people who have been arrested or charged but not convicted, the human rights of a defendant have to be balanced with the right of a society to be safe and free from crime, and that's a complicated but important task. So, it was a concern to us when in the committee scrutiny of the bill, concerns were raised by the Law Society, the Human Rights Commission and the Policing Board's Human Rights Advisor around the proportionality of some elements of the bill, and when they questioned whether some of these elements were compatible with Article 8 of the ECHR. We identified issues around the retention periods for individuals who have been acquitted or where an allegation isn't prosecuted, as well as proportionality issues regarding the proposed frameworks for under 18s. And I can accept that there are cases where an individual has been assessed as posing a threat or a further risk of reoffending, but that's a hypothetical. The starting point must be the presumption of innocence. We require in human rights law more than a speculative possibility that retained data might one day prove useful. Interferences with privacy must be necessary and proportionate, and the state must provide a compelling justification for retaining information of people who, in the eyes of the law, are innocent. The European Court of Human Rights has repeatedly emphasised this principle, including in the Marper judgment, which this bill seeks to remedy. In this case, the court was particularly concerned by the retention of biometric material belonging to people who had not been convicted of any offence. Amendment 5 therefore seeks to remedy this by restricting the right to retain an individual's data when someone is arrested or charged with a qualifying offence but has been acquitted or hasn't been prosecuted. And I know my colleague Ciara Ferguson is going to touch more heavily on the retention framework for under 18s, but we're seriously concerned that the bill as drafted goes beyond what is necessary. We know, and the evidence tells us, that when young people and children are systemised, they're more likely to remain in the system, and we know the problems that we have. We know the societal influences that lead to crime and the problems that we have in the north. Yeah, I will give way. Yeah.
Way, and I don't disagree with her about young people being brought into the official justice system prematurely when there are alternative disposals, and that's something we'll debate later on as part of amendments to the bill. However, the retention of DNA does not institutionalise or retain a young person within the justice system. It is simply kept on record. If that young person goes on not to offend again, that data will never be relevant and will eventually be expunged, in most cases after 5 years. years, and it's only where that young person continues to offend where the data becomes relevant. So whilst I agree that contact with the formal justice system, for example, such as incarceration or other forms of custody, are detrimental to young people's rehabilitation, I don't think that the retention of DNA and fingerprint data has any meaningful impact upon young people's ability to be rehabilitated after having committed offences. And indeed, I think that it is helpful to young people who then could be potentially eliminated from police inquiries, who might otherwise, because of previous offended behaviour, be the focus of police inquiries when certain offences occur.
Emma, I kind of suspected that the Minister was going to intervene. She's intervened in every speaker thus far. So the Business Committee has arranged to meet at 1 o'clock today. I propose, therefore, by leave of the Assembly, to suspend the sitting until 2, when this debate will continue after question time, and you will be the first member to be called. So the sitting is by leave suspended.
Sitting is recommenced, and we now have questions to the Minister for Health, Nicole Podrick de Largy.
Mr. Speaker, I will answer questions 1 and 4 together. The Department undertook an information gathering exercise in mid-2025. This was to inform the Executive's consideration of a multi-year budget for financial year 26-27 and the subsequent 3 financial years. In recognition of the importance of progressing the new emergency department facility at Altnagelvin as quickly as possible, the Trust submitted proposals in July of last year to rephase an original project plan. The budget cost for this initial phase is £73 million. The information provided by the Trust to the Department was included in the capital budget bid submitted to the Department of Finance. My ability to commit funding will depend on the Department's capital allocation from the budget process and the identification of sufficient recurrent funding to meet any additional resource costs associated with the facility. If sufficient capital and revenue funding is available, the Trust will have to update and submit their outline business case to the Department for approval.
I thank the Minister for his answer, and I thank the Minister for many of the interim steps that he's put on to try and resolve the issue in Altnagelvin. Altnagelvin is built for 40,000 people in terms of the emergency department. It's currently seeing 80,000 people per year. What can we do collectively in this Assembly to try and push that forward and to ensure that there's an adequately sized and adequately resourced emergency department in Derry?
Well, I am aware that the numbers are way beyond what the capacity and the build was intended to meet. So what we're trying to do is create those alternative pathways, urgent care, etc., etc. Also, just to try and make sure that only people who really need the emergency department are presenting at the emergency department. But I am aware it is the oldest of the big emergency departments in the region. I have visited it. I've visited it when it is extremely busy, and it's not anywhere near where we would want it to be, not just for the patients, but also for the staff. And I say again, they are making decisions, not the best decisions that they have been trained to provide, but the least worst, because that's the environment in which they operate.
No points of order taken during question time. You can do one afterwards. I call Julie Middleton.
Mr. Speaker, and thank you, Minister, for your time in answering today's question, as well as the work you have undertaken towards the Altnagelvin project thus far. Minister, patients facing a mental health crisis have to actually walk through the emergency room. It is often, actually more than often, incredibly busy. I know last night, for example, there was a pregnant lady that had to sleep on the floor, which isn't ideal, and it's certainly not what any of us want. I was wondering if and when funding is sourced, if that could be mitigated or if that could be considered, please. Thank you.
Minister.
Well, the member makes a very pertinent point, because there was a tragedy at the ED of the Royal just a few weeks ago. And it has convinced me, if I needed convincing, that often an emergency department is the last place a patient with mental health issues should be going to and should be waiting in. I visited the Mater Hospital a few days ago. They have what they're calling PATH, which is a separate room on the first floor, which is designed to be somewhere to be an alternative for mental health patients to avoid ED. They want to expand that. I would love to see it expanded around all the acute hospitals. I can't give you detail on that, but that is, in my mind, the ideal direction of travel.
Mark Durgan.
Speaker, I thank the Minister for his answer thus far. There's certainly recognition that the improvements at Altnagelvin need to happen, but we have to re-emphasise that they need to happen now. And while the outdated physical state of the emergency department is one thing, and hopefully the business case is accepted and the funding is acquired to complete that, but we all know that the reasons for delays and long waits rest at the back door of the hospital rather than the front. Has the Minister any plans, or is he aware of any plans, to increase the capacity of care home beds in the North West area?
I'm not aware of specific plans, but the member is right. I mean, I think when I took up post, everybody was focusing on the issues at the front door, the delayed handovers for the ambulances and the overcrowding in ED, but the member is right. The problem is the flow out the back door and building community capacity is something that we have to fix. Otherwise, we will not get the flow right. But where are the resources and where is the funding to do that? Because the department currently sits without a budget, but based on the draft budget with a shortfall of 760 million. It's unprecedented, it's unmanageable, and it means we can't do what you and I both know needs to be done.
Moving on, Justin McNulty.
Kirsten
Minister.
Encompass is now fully live across all 5 geographic health and social care trusts. It provides a single digital health and care record that supports safer, more joined-up care for people right across Northern Ireland. It's a major, once-in-a-generation modernisation. It's also an essential foundation for service reform. Independent assurance has been used as part of our oversight toolkit at key milestones. A recent review described the regional solution as robust and assessed delivery as feasible, while also being explicit on the issues that continue to require active management attention. The benefits are increasingly becoming tangible. Staff now have far better access to timely information. It reduces duplication and it supports faster decision-making, with improvements expected to grow as optimisation continues. Patients and service users are also benefiting from increased transparency and digital access through the MyCare portal. That's an app with over 300,000 people already signed up.
Mr McNulty.
Thank the Minister for his answer. Minister, since the go-live of this system in May 2025 with no GP data integration, at a projected cost of nearly £2 billion to the Department of Health and the Executive, healthcare professionals have noted a reduction in patient throughput because of overburdensome and clunky data entry requirements from a system that was not built for use in healthcare. Minister, notwithstanding the merits outlined, do you not think it's beyond credulous that a system that was designed to increase efficiency is impeding the work of healthcare professionals? And has a post-project evaluation review been conducted?
As I understand it, it was always accepted that the rollout of Encompass would slow down while people transferred from paper, but that the long-term benefits have very much outweighed any short-term hiccup in terms of slowing down procedures. As yet, there has not, to my knowledge, been a review because Encompass is still being rolled out. I've said before, and I've expressed it as a form of frustration, that apparently it can take up to 2 years after it's installed for it to be up and fully operational. And as a member will know, it was only May of last year that it was rolled out across the final one of the 5 trusts.
Dan Dodds.
And thank you, Minister. I know that many healthcare professionals value Encompass and the way that they can access patient records much more easily. Is there a central policy document on access to Encompass which would protect healthcare professionals in a scenario where I don't know, where they need protection as to how they access Encompass, when they can access Encompass, etc., etc.? Or is that something that the individual trusts would be responsible for?
Well, if I understand the member correctly, this is about putting in a layer of protection and security to a system whose essence is that everybody in HSC can access it. And I mean, that is part of the beauty of it, so that if a patient is being transferred from one hospital to another in an ambulance, the receiving consultant and team don't have to wait to receive the paper file that comes with the patient. They can go on Encompass and prepare themselves. The difficulty is, will people who have access to Encompass be using it, I'm going to use the word prurient, or a voyeuristic way? Are they going to be looking at it? I have been in discussions with our digital team, and we have now come up with a warning that will appear on the home screen every time somebody logs into Encompass, to warn them that inappropriate access of information could result in disciplinary action. In fact, it could even result in criminal prosecution.
Sure, Dixon.
Minister, for your answers so far. Minister, you've been talking about the excellent work that Encompass does. However, the regional Encompass team recently wrote to GPs expressing concern that some 12,000 red flag letters and other pieces of correspondence just seem to have gone missing from the system. GPs are very rightly concerned that they're not getting the appropriate feedback from Encompass about their patients. This is a matter of serious concern. I've got a letter here from a GP complaining about 12,000 letters, some of which are red flag, some of which are downgrades, and they simply haven't got them.
I am aware of this, and I again have discussed it with the digital team, and apparently there were 2 fail-safes that failed. So by definition, they are not fail-safes. But the only assurance I can give people is that while it is unacceptable that this happened, these were referrals which were rejections by consultants. So no physical harm was done, but obviously if you are waiting for the result of your referral and your GP assumes that you've already got that the GP has that information, that is just not an acceptable situation. So work is still ongoing in terms of investigating, but there were failures within the process, and I accept that and apologise for it.
Dr. Aiken's not in his place. I call Palm Cameron.
Aligned with the Regional Dementia Care Pathway, my department remains firmly committed to strengthening and enhancing dementia training, and I very much accept the members' long-term interest in this area. The Regional Dementia Project Board plays a central role in this work, with a dedicated work stream focusing on education, training and research specifically. Through the work stream, significant progress continues to be made developing and expanding high-quality dementia training. This includes building on existing programmes and introducing more specialised learning opportunities, such as the development of Dementia Relationships, a rights-based approach training alongside Queen's University. It's available online through Learn HSC NI. The initiative has been supported through funding from the Department of Health. It's aimed at improving staff understanding and delivery of person-centred care. In addition, the Department has endorsed the regional rollout of an online dementia-related pain management training known as DOTS. It's been developed and researched by Ulster University. This evidence-based programme supports staff to better recognise and manage pain in people who are living with dementia, thereby contributing to improved outcomes. The work stream is also updating the Dementia Learning and Development Framework from 2016. This sets out the core knowledge and skills required by health and social care staff to enable them to interact appropriately and respond sensitively to the needs of people living with dementia, as well as their families and their carers. There'll be an online version of that, will be accessible to all stakeholders and easily navigated to signposting to relevant training and resources.
Mrs. Cameron.
Thank you, Mr. Speaker, and I thank the Minister for his answer so far. Also welcome the work undertaken by the representatives in the Regional Dementia Project Board and the review into care standards. But research from the Alzheimer's Society indicates that around half of all training programmes provide only 1 to 2 hours of instruction. So that suggests that coffee baristas often receive more training than care workers in supporting people living with dementia. So will the Department consider introducing a statutory requirement for all social care providers to ensure that direct care staff complete best practice dementia training?
At present, there's no statutory requirement, as the member knows, to mandate dementia awareness training across the system. I would strongly endorse the importance of such training as a key element of workforce development, but the member will not like this because it is not proposed to introduce a compulsory requirement at this time. The Department operates within an enabling framework where employers retain responsibility under existing employment and professional regulatory arrangements to ensure their staff are appropriately trained and competent to carry out their roles. This approach allows for proportionate implementation while supporting organisations to embed dementia awareness within their broader training and their governance structures.
Ferguson.
Just on that same area, Minister, it's really critically important given the increasing prevalence of dementia, and just personally I want to note, obviously I care for my mum who currently has dementia, and we have caregivers coming into the house twice a day, 7 days a week. So I'd like to ask, I want to reiterate how important it is for staff across care homes, domiciliary care and community services get good training. So on that, I'd like to urge you again, what can the department do to ensure all our staff who are at the coalface of supporting those most vulnerable in their homes do have access to good training, and then how can that be monitored and tracked to ensure that we know it's having an impact on the lives of individuals and their families? Thank you.
Well, I think the best thing that the department to do is to ensure dementia training remains current and that it remains aligned with best practice, and we do that through collaboration, not least with academia, but also with clinical experts and alongside the established governance structures. But the prevalence of dementia is so high, I would be very surprised if anybody within the HSC workforce who comes into contact with people with the condition are not keen to keep themselves trained and aware and up to date with developments and how best to look after it. It is a massive problem, but there are many areas where the workforce has to be trained up, and that's why I think it's impossible to say it has to be statutory, but it's very important for many people that they keep themselves up to speed.
McAllister.
Mr. Speaker, of course training is important even before diagnosis takes place, but there is an issue currently around that, and I have wrote to you, Minister, regarding GP's concern on the referrals to psychiatry, including possibility of dementia, and how a lot of that is bouncing back now because there is no workforce that can act to capacity there. Do you have an update on where we are with the psychiatry workforce, including the reassurance for anyone who may need a diagnosis of dementia?
I'm afraid I don't have an update to hand on the psychiatry workforce. I'm more than happy to write to the member. As the member knows, in the Department of Health and Social Care, we live in a world of statistics, and it's very hard to retain the number that you would need to retain to be able to answer all the questions that members legitimately ask in these sessions.
Diana Armstrong.
Thank you, Mr. Speaker. Thank you for your answers so far. This is a really important and valuable training programme referenced in the question, and I welcome the collaborative approach with the universities. Minister, can you explain how the department monitors the uptake of dementia training across different sectors?
Yes, my department monitors uptake across different sectors through a combination of established governance, of reporting and workforce oversight arrangements. Trusts are required to track and report on staff participation and completion rates as part of their existing training and performance management processes. In terms of the independent and voluntary sectors, the department will work with relevant commissioning, regulatory and partnership mechanisms to promote uptake and gather assurance on training activity. This includes engagement with providers to ensure alignment with agreed standards and expectations. Regional oversight is provided through the Regional Dementia Project Board. They will review progress, identify gaps and support continuous improvement. That's an approach that enables proportionate monitoring while ensuring dementia training is being consistently embedded right across the system.
Moving on, question 6 is withdrawn. David Loughlin.
Question 7.
I fully acknowledge the essential role played by domiciliary and home care staff, supporting people to remain safely in their own homes and thus alleviating pressure on our acute services. Home care workers provide far more than just practical or personal care and support. They provide reassurance, continuity and human connection at moments of vulnerability. I remain fully committed to the implementation of the real living wage for home care workers, and that's in recognition of the vital frontline role they play, supporting vulnerable individuals to live independently at home. However, I'm not in a position at this stage to confirm a definitive timeline for implementation. That's due to my department not yet having a confirmed budget settlement, and we continue to face the significant financial pressures I've already alluded to. Notwithstanding those constraints, I've made clear repeatedly the real living wage remains a priority and will be implemented at the earliest point that it becomes affordable, and importantly, once introduced, the uplift will be backdated to the 1st of April 2026 reflecting my commitment to that workforce.
Ms McLaughlin.
Thank you, Minister, for the answer. Obviously, domiciliary care workers are actually highly skilled individuals, and you referred to the back door of the hospital in order to support the A&Es. But, Minister, there is an awful lot of money that is spent on agency workers. It's a colossal spend. Is there any way that you could get to grips with that spend and move towards giving people proper pay for a really highly skilled job?
Well, the member's right to talk about the money that is spent on agency workers. Now, agency workers are used to make sure that we are delivering safe services, and we would only use, for example, agency nurses if the bank has been exhausted, the pool of bank nurses has been exhausted. We have had 100% success, I believe, in terms of social care workers we no longer use agency. We're now looking at nursing. We're now looking at locums. There is an acceptable level, a necessary level of agency and locum work to keep delivering safe services. But we're way beyond that, and we need to crunch it down.
Linda Dillon.
Brilliant. Thank the Minister for his answer. Minister, it has already been outlined the skilled workforce that our domiciliary care workforce are, and I don't think anybody can deny that. But we heard from the Royal College of Emergency Medicine last week in the Health Committee that the real issue for them in emergency medicine is the flow. So we are not getting people out the other end, and that is because we don't have enough social care staff. So we're actually spending millions and millions of pounds keeping people in hospital when we actually could be investing that and giving the real living wage to our domiciliary care workers, and also giving them sufficient mileage. And I'm thinking of particularly those who work in my area, which is a large rural constituency, and they have real challenges now being able to deliver services
good preamble.
to
Can we get to the
that they
question,
care
Mr.
about and that they want to serve.
Well, I agree with the member that the problem is community capacity, both in terms of domiciliary care workers and packages, and in terms of care homes and care home beds. But where is the money to do that? Because, yes, we're spending a lot of money on bank and on agency, but if we stop that flow of money and divert it to creating more community capacity, then the hospitals become unsafe. So, we are running the health service. If it was a train, we're running it on a track that we don't want to run it on. We want to build a different track and run it on that track. We can barely afford to run the track we're on, never mind create the track that we all know we need to create. So I don't have the solution because I don't have the money. We know what to do, we know how to do it, and the frustration is we don't have the cash to make it happen.
Andrew McMurray.
Minister, and the issue of domiciliary care is at this stage well rehearsed, and we do know the contribution they make to society. Only this week I was discussing with the domiciliary care emergency about the challenges she faces in trying to manage the issue. But what evidence has the department gathered on the impact of the living wage implementation on recruitment and retention of domiciliary care and the vital service they provide?
Well, I am sure it is very bad for morale. I understand the disappointment, and I have previously acknowledged my decision was counter-strategic, but it was unavoidable given the financial constraints that I'm facing. Social care staff make an essential contribution, absolutely, and they could do more if we had more of them. And I do share the ambition to establish the sector as a real living wage sector as soon as the finances allow. That is a very important step towards improving the flow out the back door, but there's more to be done. Mileage allowance, terms and conditions, work-life balance, they're all in the mix.
Alan Chambers.
Can the Minister confirm that he's committed to implementing the real living wage for both statutory and independent sector care workers?
Yes, I've been clear. My commitment is to implement the real living wage across the social care workforce, and I've set this out directly with the key stakeholders. I wrote to trade unions to confirm the pathway to deliver the real living wage through Agenda for Change arrangements from 26-27. I then wrote to members of the Social Care Fair Work Forum to reaffirm my commitment to implementing the real living wage for independent sector adult social care staff, again from 26-27, with any uplift backdated to the 1st of April. Taken together, these actions demonstrate a clear intention to deliver the real living wage across both statutory and independent sectors, subject, of course, to the availability of funding and final budget decisions.
Peter Martin.
Question 8, Mr. Speaker.
Formal guidance issued by the British Society of Gastroenterology in 2014 specified that a robust diagnosis of celiac disease should involve an endoscopy procedure and accompanying biopsy. This was followed by interim guidance in 2020 regarding a no biopsy protocol, which was intended to support the timely diagnosis during the COVID-19 pandemic at a time when our endoscopy capacity was significantly reduced. This pathway allowed diagnosis based on blood tests alone under specific conditions. To date, the guidance issued in 2014 remains the formal guidance. It limits the scope to adopt no biopsy pathways at scale. Broad adoption would require updated formal guidance from the British Society of Gastroenterologists, followed by the issue of clear referral guidelines to primary care based on that guidance.
Mr. Martin.
I thank the Minister for his answer and also for outlining where we are in terms of early diagnosis of celiac disease. I want to thank him for his commitment on this issue to try and ensure the best pathways and the most expeditious pathways in terms of getting diagnosis for it. Will the Minister commit to meeting with some representatives of Celiac UK to discuss this issue for sufferers in Northern Ireland?
Always happy to meet advocates for particular conditions, absolutely.
Shall Guy.
Thank you, Mr. Speaker. Given that around 1 in 4 people with celiac disease have previously been treated for IBS, how is the Department ensuring that patients with persistent gastrointestinal, I knew I was going to get over that word, gastrointestinal symptoms are appropriately screened for celiac disease?
Sorry, if I understood the member correctly, how will the independent sector? Is that okay?
Okay, so how would the Department ensure that patients with persistent gastrointestinal symptoms would be appropriately screened for celiac disease?
Yeah. Well, there are always robust government arrangements in place, whether we're doing it within the health and social care system or using the independent sector. That would apply to all the work that we do.
Alan Robinson.
Mr. Speaker.
I fully recognise receiving a recall letter in relation to these cardiac therapy devices can give rise to understandable anxiety and distress, not only for patients, but for their families and friends as well. Therefore, it's essential appropriate support, reassurance and timely clinical assessment are in place throughout this process. The Belfast Trust are treating this matter with the utmost seriousness, as am I. A structured and carefully managed phased approach has been undertaken, contacting and reviewing affected patients. The Trust is working to ensure individuals who receive a recall letter are offered an appointment aimed at minimising any prolonged period of uncertainty and ensuring patients receive appropriate clinical advice and, where necessary, timely intervention. In addition, a dedicated patient advice line has been established. It provides patients with a direct and accessible point of contact. I should stress this support is not limited solely to those who have received a recall notification. Any patient who has concerns about their device, whether or not they have received correspondence, is encouraged to contact the advice line for clarification and support.
Mr. Robinson.
Thank you, Mr. Speaker, and I thank the Minister for that response. Given, Minister, that concerns were raised back in 2020 by staff, but action appears not to have been taken until 3 years later, what changes will now be introduced across health and social care to ensure concerns raised by staff or patients about these procedures are acted upon more quickly in future?
Yeah, well, the issue has been under active review since concerns were first emerging, and the Trust has been progressing a careful, clinically led look-back process in line with established guidance. During that time, the priority has been to ensure the information is validated and that patients are contacted in a structured and supportive way rather than causing unnecessary alarm. But as a broader point, I would say to the member that any time something goes wrong, as the Minister, I would expect an early alert. In other words, I would expect to be alerted that there's a problem or a potential problem in real time. And these arguably lengthy delays in problems coming into the public domain are not acceptable to me. Responsibility for ensuring equitable access to domiciliary care rests with each trust. At a regional level, the Department works closely with those trusts through the Social Care Collaborative Reform Board and its implementation groups. My department has developed a 10-year strategic plan together with a 3-year delivery plan to implement a reform agenda. Domiciliary care is an important element of this, and one of the Social Care Collaborative Reform Board subgroups has been tasked with developing a sustainable adult social care system that can meet the future needs of people requiring care and support. This work includes establishing a new regional model for domiciliary care, including an updated domiciliary care contract. My department has also held a series of roundtable meetings with key stakeholders from right across the sector. The purpose: to explore and learn from good practice in each of the trusts and review any additional measures that could be taken.
We have to move on to topicals. Call Colin McGrath.
Minister, our fire and rescue service go above and beyond the call of duty on a regular basis. Recently, they responded to 2 fires at 2 waste processing sites. What direct engagement have you had with the fire and rescue service following these fires, and what has been the outcome?
Well, I haven't had any direct contact with the fire and rescue service on those 2 specific fires, but today I was signing off 3 Assembly written questions from yourself on that issue and the numbers in terms of waste management sites and other areas.
I look forward to, with interest to receiving those. And of course, our main priority should be in fire prevention and waste operators' compliance with fire prevention plans. To that end, can you give me your assessment on the DAERA Minister's response to me, in which he said, from NIEA's perspective, it is not the case that all sites can be confirmed as fully compliant at all times? And what message does that send to our dedicated firefighters?
Well, I have no worries over the Department of Agriculture, Environment and Rural Affairs. What I would expect is that people would respect the role of our firefighters in the Northern Ireland Fire and Rescue Service, except that at times they are putting themselves physically and mentally in harm's way to keep the public safe, and therefore I would ask everybody in a position of responsibility or authority to make sure they do all they can to keep our firefighters safe, or when they have to put themselves in harm's way, that everything has been done to make sure the environment is as amenable as possible.
All right, Harvey.
Thank you, Mr. Speaker. Minister, you may be aware of a social media post at the weekend by the Public Health Agency which advised musical festival goers to, and I quote, start with a small dose when taking drugs. Does the Minister agree with me that such messaging is totally unacceptable?
Well, I take a rather practical view of the use of substances that are banned or illegal. They are with us, they have been with us a long time, and they will be with us for a long time to come. So I know there are some people, including those in the Members' Party, who say the only acceptable message is do not take illegal drugs. That's a position that is perfectly valid and that I acknowledge, but I don't think it is practical. People do take these drugs. Going to a concert is probably one of the occasions when they're most likely to take them. So I am into mitigating the damage. So, for example, I was at a 4 Nations meeting on drug use in Scotland last year, and they are so concerned about people injecting a certain Class A drug that in one 12-month period they gave out 400,000 pieces of foil to try to encourage people to smoke the drug rather than inject it to avoid a blood-borne disease. That is a practical step that I support rather than trying to say that it is possible to stop the illegal use of drugs.
Mr. Harvey.
Minister, if I could just ask you who signed off on this, maybe, please. Thank you.
I will check that out. I'm not sure that I signed off. It's not striking a bell with me. Obviously, the arm's length bodies have a certain autonomy. It was the Public Health Agency, as the member says, who posted it. I'll certainly check it out and write to the member.
Can I ask the Minister to outline the current level of provision for post-19 adults with complex needs in the Southern Health and Social Care Trust area, including access to respite services and day centre care, and maybe more importantly, or maybe easier, to detail any plans for investment and the expansion of these services in the Southern Trust?
Well, again, that's a level of detail and a set of statistics that I'm not carrying in my head and I don't have on file, so I'm more than happy to get back to the member on it. I think that this executive, and probably more likely the next executive, needs to do a lot of work and legislate in this area to make life better for those who need it.
Thank you for the Minister, and I look forward to receiving it. Given that the Oak Ridge Learning Centre in Dungannon has been identified as a priority for a new build for over 20 years now, will the Minister outline when families can expect to see progress on this long-standing commitment, and whether this project will be included in forthcoming investment plans for services for adults with complex needs in the South Tyrone and Southern Trust area?
Minister.
Well, what I'm not going to do is encourage the member to speak to his colleague, the Minister for Finance, because I know the Minister for Finance wants to bring forward budgets, both for resource and for capital. But without a budget on capital, I can't make a commitment. I need to know what my budget is, and then we have to look at the priorities. And I wouldn't be particularly optimistic that that venue will be high up on the list. There are a lot of demands. In an ideal world, of course, I would say to you, I would make that commitment right here and right now, but I'm not in a position to do so, and I regret that.
Butler.
Minister, like many, I really welcome the announcement last week when you secured the Executive's approval to spend this year's £80 million on the elective waiting list. But one of the other good pieces of news was the transformation funding, also announced last week. So what impact will that funding have on particularly the Together for Families project?
Well, I think this is really transformational. I think it's also a once-in-a-lifetime opportunity to switch how we intervene with families who have young people who have real issues. It's an opportunity to keep them out of care. It's an opportunity to get away from reactive statutory interventions into early community-based support. And that, of course, is entirely consistent with my desire that the health and social care system shifts left into the neighbourhood model. And so I just think it is absolutely transformational. I'm very, very grateful to the Transformation Fund for that £30 million, or just shy of £30 million, and I promise the member it will be well used.
Thank the Minister for his answer. On the money that has been pledged by the National Lottery, how do you think that reflects the value that agencies like the National Lottery put in, and have confidence in the ability of a project like this to turn the lives around of those young people who desperately need that intervention?
Well, I think it says two things to me. First of all, it talks about the confidence that they put in the Together for Families project, because it's £30 million. That's an unprecedented investment in a project of this scale by the lottery here in Northern Ireland. But even if it was only £1 million, or maybe only £500,000, I am convinced, they would do their due diligence in terms of sweating the proposals and just convincing themselves or assuring themselves that the plan was a solid and a robust one. But the second thing I think it says is the value of partnerships. And as we try to shift left, we are looking to others to come in and help us with funding and resources. So as well as this, the member will be aware in terms of our Cancer Charities Fund, which is relatively new. We put £1 million in, but Macmillan Cancer Care matched that with another £1 million, so we got £2 million. And that has to be how we work in these really constrained financial times, to try and gather up pots of money which will enable that shift left into the neighbourhood model.
Tom Buchanan.
Minister, why was your assessment of the cervical screening failures, including the 6 reports and decision not to establish a statutory public inquiry, confined almost in its entirety to the Southern Trust, excluding all the other trusts, despite clear evidence that women in these trusts also received incorrect results?
Well, the focus that I inherited was entirely on the Southern Trust, so that's why we pursued that to its conclusion. Well, it may not be the conclusion. Obviously, the ladies with letters and others are considering potential next steps, and that, of course, is their right. But I have been aware that there are women in the Western Trust who also had issues. I am going to refresh myself on those situations because I believe it's not directly readable across with what happened in the Southern Trust. But Sinead McLaughlin has written to me asking if I will meet with some of those women, and I have signed off on that today, so we will find a diary date to make that happen.
That, Minister, and that's welcomed. And do you accept that the women in the Western Trust were denied the same level of scrutiny and potential redress as those in the Southern Trust? And again, on the back of that, is the real reason the Western Trust was excluded was that if it had been included, it would have revealed a much larger systematic failure that would have made the case for a statutory public inquiry unavoidable?
I don't accept that, actually, and I'm just trying to remember, and I think, as we know, the Southern Trust didn't follow the kind of standard procedure of one full review and then one quick review. They went for 2 full reviews. Of course, they did that with the best of intentions, but it meant that we couldn't benchmark against other services, and that was one of the big problems for them. From memory, with the Western Trust, their barrier or the level at which you pressed the warning light was different. But look, I am going to refresh myself on that. I say I am going to meet the people that Sinead McLaughlin wants to bring to me, and we will see where that takes us.
Minister, can I ask what progress the SPPG have made in addressing pay disparities between pharmacists employed by GP federations and those employed directly by health and social care organisations who are undertaking equivalent roles?
Minister. Well, the thing is, you see, GP federations are not a health and social care body. So those pharmacists in the GP federations are employed by the GP federations. So it's up to the federations to determine their pay and conditions. We have no locus there, but we did provide uplift for staff costs to federations in respect of their pharmacists on the basis of the pay award agreed by the Doctors and Dentists Review Body, and I think we've done that for last year and are committed to doing that for this year if and when we get a budget.
Ms. Egan.
Thank you, Minister. My understanding is both pharmacists representatives and GP federations support alignment with Agenda for Change. So do you expect a decision to be made on pay parity?
Well, if the federations support pay parity with the Agenda for Change, they should just do it.
Timothy Gosson.
Minister, in the aftermath of the Clive Johnson case, a number of pastors have contacted both your department and the police seeking clarification on how safe access zone legislation applies to ordinary pastoral ministry within hospital settings. Has the Minister any plans to issue guidance relating to these concerns?
If I'm asked to issue guidance, I certainly shall. I was not aware that there was any uncertainty until the member spoke just there, Mr. Speaker, but perhaps he could elaborate on that, and then that will inform a decision on whether we go with renewed or new or fresh guidance. Absolutely.
Thank you very much, Mr. Speaker. If a pastor preaching on John 3:16 can result in successful prosecution outside Coleraine Hospital, it's not irrational thinking that he could be ramifications for reading John 3:16 inside the hospital. Does the Minister share my concerns that the very fact that this issue is concerning Christians is testament to how badly drafted this law is?
Well, I'm not sure I agree, but I'll certainly look into it. But I think, common sense should apply, and I'm not sure we're comparing like with like in terms of reading a biblical passage one-on-one to a patient within a hospital and what happened out on the streets.
Doug Beatty's not in his place. Call Michelle Guy.
Thank you, Mr. Speaker. The release to rescue improvement patient flow through hospitals, or has the release to rescue improve patient flow through hospitals, or has it simply improved ambulance handover statistics?
Well, reducing those delays was something I had to do. It was implemented on the 27th of April, as the member knows, and she's identifying the downside of it because, as we've discussed already in this session, this isn't just about the front door, it's about the whole flow through the hospital, out the back door, and into the community where we need more health and social care capacity. So I have to say, I had meetings with clinicians, with hospital administrators, and with the trade unions. I had a couple of meetings. I felt that this was going to take a long time to implement. But the initial responses in terms of what's happened since the 27th of April, in terms of hospital handover times from the ambulances, is really, really good. And I just want to commend everybody involved, because it's not just the ambulance crews, it's the intake, it's the nurses, it's the clinicians, it's the administrators. But it's only part of the problem, and it's only part of the solution to a bigger problem.
That concludes questions to the Minister. Congratulations, Minister, by the way. You got 2 10s today, and that's considerably better than normal, so well done on getting through so many questions and so many members having the opportunity to question you. Members, just before we move to the Justice Bill, I want to make a few remarks on the consideration stage of the Inquiry Mother and Baby Institutions, Magdalene Laundries and Workhouses and Redress Scheme Bill, as a number of members had raised points of order in relation to the selection of amendments. A number of those were in tone which were out of order. I do not intend to return to that on this occasion, but neither do I intend to breach the long-standing conventions, here indeed elsewhere, that the Speaker does not give reasons for his or her decisions. However, I do fully recognise the sensitivity of these issues, and I appreciate that victims and survivors of abuse are more interested in the details of the bill. Therefore, I wish to make some limited comments today, which hopefully can assist the House. Understanding Order 15(5), it is for the Speaker to decide which amendments proposed to a bill, if any, will be debated. Often this involves complex issues and requires the Speaker to make balanced judgments. I fully acknowledge that I approach these matters both from a perspective of my experience as a Minister and developments around legislation in recent years. I have previously told the House that I take a rigorous and cautious approach to my decisions, and members will be aware that the Marshall List for consideration stages of the bill did not issue unusually until a Saturday, and that is because I went through those amendments in detail over and over again before I reached the decision. However, it is not the Speaker who determines the contents of a bill presented to the House or proposes the amendments to it. The bill was brought forward by the Executive Office, and clearly many victims and survivors were disappointed with certain provisions in it. And in accordance with Section 13(1)(a) of the Northern Ireland Act 1998, the general principles of the bill were agreed by the Assembly on the 24th of June 2025. The committee then engaged further with victims and survivors and proposed a number of amendments. I want to be clear to the House that the fact that the committee amendment removing clause 31 of the bill was not selected at consideration stage should not be interpreted as meaning that a different amendment, proposing an alternative date or approach, cannot be tabled or selected at further consideration stage. Before the consideration stage, there was a positive and constructive engagement between the committee and the Executive Office, and this included ministers bringing forward amendments in response to the committee's views, and the committee agreeing to withdraw its amendments in support of those proposed by ministers. And members will also be aware that at further consideration stage, it is the last opportunity to bring forward amendments to a bill. Therefore, normal that ministers bring forward amendments at that stage to tidy up changes to a bill in order to ensure that they are practical and effective, as well as to ensure that there is a coherent statute book. It would therefore be preferable for any attempt to address the concerns of victims and survivors in relation to the posthumous date to be taken forward by a ministerial amendment from the Executive Office. That is a matter for ministers to consider, and I'm sure the committee will be active in encouraging them to do so. It is also right that the committee, indeed any other members, should continue to engage with the Department on the details and technicalities of any further amendments. I make these remarks today to emphasise that the passage of the bill is not yet complete, and therefore remains the ability to amend it in line with the principles agreed at second stage. I have gone further than a Speaker normally would before a bill returns to the House, and I don't intend to take points of order on the matter. However, I hope that this helps clarify and manage expectations around just what is possible from my perspective at further consideration stage, and what is possible from a policy perspective is for the Executive Office to advise on and for the Assembly to ultimately determine. We now move back to the Justice Bill, and point of order, Mr. Largy.
I can't call you, and I had intended to raise a point of order earlier. During my question time with the Health Minister, I raised a significant issue around Altnagelvin Hospital. I could not hear what was being said, other members couldn't, the Health Minister couldn't hear, and I think it's deeply disrespectful to people in Derry that the SDLP health spokesperson continued to have a loud conversation during this and continues to have loud conversations during many debates. I find it deeply disrespectful to the people of Derry, and I think an apology should be issued.
I thank you, Mr. Largan. You have raised this issue before privately with me. Personally, I didn't hear Mr. Durkin's conversation, but I'm not disputing what you're saying. But it is for members to seek to ensure that they are heard, and that members can also hear what is being said in the chamber. And I think that is important. It wasn't because of heckling, it was because of conversation in this instance, and people should reflect upon having conversations in the House, that if they want to do so, they do it in whispered tones as opposed to loud tones. So thank you for raising that, Mr. DeLargy, and I ask members to take note. Moving on to the Justice Bill, the consideration stage, and I call Emma Sheeran.
Killing Corlia, and here to eat my words after being overambitious that I would have been finished before lunchtime after preaching to Paul all week about the length of time that we speak, so that's a bit of a lesson for me. So I want to, I suppose, just return to what we were talking about prior to question time and the break for lunch, in terms of the Minister's response around the retention of biometric data for under 18s, and I suppose I would refer to the judgment that we heard in the wake of the Marper judgment from the Human Rights Commission, where they stated very clearly that the evidence tells us that there is a stigmatising ill effect on individuals, especially children, when their data is held, and that research tells us once a child is in the criminal justice system, it almost sets them on a path as such, and we should be ensuring that the path to criminalisation is kept at a minimum. We need to adopt a child-centred approach to this whole area, and that goes to the heart of what our amendments to this bill try to do, in that we want to have a compassionate approach, particularly to children and young people. And obviously, in other parts of the bill and in a number of proposed amendments, children and young people are treated differently to adults, and our youth justice system should be based on principles of rehabilitation rather than punitive punishment, and that's what our amendments seek to do. We think that the threshold for retaining a child's biometric data should be markedly higher than that applied to adults, and that the Assembly should be cautious about creating a system in which children who have committed minor offences or haven't been convicted at all can have biometric data retained by the state, because we don't want to criminalise our young people and entrench them into that justice system, which then, the evidence tells us, leads to higher likelihoods of reoffending. And I want to refer very quickly to our neighbours in Scotland who have considered this issue and have adopted a different model than the one we are on the path to here in the north, as set out in the Code of Practice for the Scottish Biometrics Commissioner. So in Scotland, Biometric data for under 18s is only captured and retained for those arrested for violent or sexual offences or otherwise by exception. And since this model was adopted in 2024, there has been significant decrease in the number of children who have had their biometric data retained. The Scottish Biometrics Commissioner has stated that the outcome of this policy change better reflects the interests of children and the policy position in Scotland via incorporation of the UNCRC. Again, goes to the heart of what we're trying to do here, which is prioritising human rights, particularly the human rights of children. So the bill as drafted includes shorter retention periods for under 18s than adults, and we acknowledge that and welcome that to some extent, but we would support the Scottish approach whereby a child's data can only be retained for 3 years unless the police apply for and are granted an extension by a court of 2 years. And in answer to Mr Frew's earlier request for clarification, there isn't a limit on the number of those applications for extension that could be granted, so it isn't capped at 7 years. And I know that the Minister in bringing this bill has a commitment to strengthening legislative provisions for children. So I believe that our proposals better reflect the provisions contained in the Justice Act of 2002, that all public bodies must have the best interests of children as a primary consideration, and I hope to see support for that across the House. And those specific proposals are reflected in our amendments today, and I would ask people to support amendments 11, 12, 13, 23 and 24. Moving on to the independence of the Biometrics Commissioner, which we touched upon earlier. This has been a focus of the Marper judgment and the absence of a robust review process of the need to continue to retain DNA and fingerprints. And I don't think the concerns outlined in that judgment have yet been addressed. We had it raised in this chamber during the second stage of the debate that members were greatly concerned that the volume of proposed amendments that weren't in the bill from the beginning, and we do require clarity on exactly how the new proposals for a biometric commissioner will work. So you'll understand my concern that the bill sets out sort of a skeleton framework for an appeals and oversight mechanism, with the department stating that the review regulations, including the statutory review dates, will be subject to public consultation and then considered by the Assembly. In the bill's framework, an individual has the right to ask the PSNI to conduct a review. This review would then be conducted by a designated PSNI review team. Where an individual is unhappy with the decision made, they have a right of appeal and can ask the PSNI to reconsider the request. This appeal would then be carried out by a more senior PSNI officer. So we would have concerns there that that looks like the PSNI marking their own homework, so to speak. We know that law enforcement agencies would want to hold on to this data for as long as possible, but it is up to us as legislators to ensure that there are safeguards in place to protect individuals' rights. And in our engagements with the department, and I want to thank the Minister's team in particular for being so open to conversations with us whilst we sought clarity on a lot of these proposals, we were told that the PSNI is the data owner, and it is for the PSNI to determine if there is a policing need to continue to retain the person's material, which again reflective of our earlier conversations around the PSNI requiring this data for future investigations. We would have serious concerns about this, that this misses the point. The PSNI do not own this data. Biometric data is highly personal and it belongs to the individual in question, and that right must be protected. We agree with the department that the Biometrics Commissioner should be the ultimate authority in deciding the outcome of an appeal, and this should be out of the hands of the PSNI. So we would argue that this should not be via a complaints mechanism, as the Minister has proposed, but via a direct case handling function. So we would ask people to support amendments 29 and 32, which achieve the same by removing the PSNI as the ultimate decision-making authority, removing their ability to mark their own homework, and ensuring there is an individual with the necessary independence to carry out reviews on the basis of proportionality, fairness and rights. And again, if you look to the Scottish model and how the Biometrics Commissioner there is answerable to the whole Scottish Assembly and not to one political advocate as such. Then I want to move on to my next point. Yeah, Lanray.
I mean, to be clear, when it comes to the independence of the Biometrics Commissioner, there's no question that they would be politically answerable to anyone in the political sense. And indeed, we have stressed that we do not wish to constrain how their office would operate, in the same way that we respect the independence of the policing board, the chief constable, and indeed the police ombudsman. So I think that is perhaps a flawed analysis, and whatever checks and balances there may be in the Scottish Parliament, it is a very different construct to the Northern Ireland Assembly, and I think we need to be careful of simply importing something from the Scottish Parliament that hasn't been stress tested here in terms of its operability.
I thank the Minister for the intervention, and I suppose I stated in my earlier remarks that our key concern is around the fact that the Biometrics Commissioner, and we've teased this out during committee sessions, is ultimately answerable still to the PSNI, and that's where our concern is. But I suppose refer to the Law Society's advice that it would be helpful to refer to the Scottish model in terms of how the Biometrics Commissioner there handles this data. Yeah.
They are not answerable to the PSNI. In fact, their decisions create a requirement on the PSNI to take action. So, contrary to the PSNI being able to direct the Commissioner can direct the Chief Constable to remove stuff, and the Chief Constable would be obligated to do so. So that is a flawed understanding of how the Biometrics Commissioner would operate. It is important that they are completely independent and free to exercise their powers, and that, as I have said, will come back in terms of regulation and consultation, so that the committee and others will be able to influence the shaping of those powers and responsibilities. But there is no suggestion that the Commissioner is answerable to the PSNI. The PSNI do a first stage review. If a complaint then continues, it goes to the Biometrics Commissioner and they adjudicate, and that decision is final.
So, Minister, I thank you for this, and we had extensive conversations during the committee around this, and we've engaged with your own team on this topic, because it's been a concern for Sinn Féin from the start around the guaranteed independence of the Biometrics Commissioner. And after asking DOJ officials, we didn't have clarification that the PSNI ultimately wouldn't be the arbiter in terms of how the Biometrics Commissioner carried out their function, and they would have to take direction from the PSNI ultimately. And we're yet to receive anything to dispute that.
So now, if the member wishes to give way, I mean, it is absolutely clear that the Commissioner will be independent of ministers and independent of the PSNI, and that their role is to provide independent oversight. If they instruct the PSNI to take an action, it will be a requirement that they do so.
I thank the Minister, but the legal briefing we received from the Department in March of last year highlighted the importance of the review. The Chief Constable is not independent of the policymaker or those who will carry out the policy, which is the PSNI. The Commissioner will be appointed by the Department and must report to the Department. The Scottish Commissioner talked of the importance of independence, free from political influence. They are appointed by and only answerable to Parliament. So there's two going concerns there, and that's. I'm not saying that everything in Scotland is perfect, but we were not able to achieve any clarity around the complete independence of the Biometrics Commissioner, as you have set out in your proposals thus far, and we have concerns, as I've already outlined, as to how they would carry out their function and how we could ensure their ultimate independence. Okay, I'm going to move on to my next point, which is we feel that the PSNI need to provide appropriate information to individuals who are having their biometric data taken and retained. So when people have been arrested and are going through the biometrics process, information about the process and their rights are unlikely to be at the forefront of their thinking, and therefore we believe that the PSNI should have a duty to inform these individuals of their rights. So someone is in that stressful situation and mightn't be considering all of these requirements. This is of particular importance given the recent revelations of illegal surveillance by the PSNI on journalists and the failure of the PSNI to delete material on the back of a court order. order. So our Amendment 35 would place a duty on the Biometrics Commissioner to issue guidance that sets out the information that a custody officer should provide in writing to an individual or their solicitor, parent, guardian or appropriate adult before biometric material is obtained. This should include the maximum period for which their material may be retained and the circumstances in which they have a right to appeal against a determination to retain data, as well as the procedure of such appeals. I believe that this is an important safeguard, and we would encourage all members to support Amendment 35. And finally, I want to touch very briefly on the issue of photographs, which I know my colleague Aoife Finnegan will talk about in great detail later. We obviously, along with other colleagues on the committee, are clear that this legislation needs to be future-proofed. Technology is moving very fast, and we know that existing PSNI practices should be accounted for in the biometric framework, and that currently the PSNI already regard photographs when they've went through that process as biometric information. So we think it's a pity that photographs were not included in the bill, but we welcome the fact that others have suggested that they will be supporting the committee amendment number 40 in terms of the future addition of photographs as biometric material, and I want to thank you at this stage.
Conaghan.
Thank you, Mr. Speaker. I welcome the opportunity to make some comments during this consideration stage debate of the Justice Bill. I first joined the Committee for Justice in November 2024, shortly following this bill's introduction to the Assembly. Now, after an 18-month committee stage, I am pleased that we are finally getting to debate these contents. As we know, this bill is incredibly varied and mixed in what it covers, tied together with the aim of building a more effective, efficient and modern justice system for all across Northern Ireland to benefit from. This follows judgments including S and Marper versus the UK and Gaughran versus the UK in the European Court of Human Rights. Part 1 of the bill clearly aims to put human rights at the centre, providing a balanced and proportionate retention and destruction framework for DNA and fingerprints in Northern Ireland. I will start with the amendments listed under the Minister of Justice's name, which Alliance plan to support all of. As recognised by others, this Amendment 1 is an incredibly complex area of law, and it's clear the Minister and her officials have put in detailed consideration to its components. I wish to draw attention to some of the specific contents of the clauses and schedules outlined, beginning with Amendment 1. This edits Clause 1 to allow the PSNI a more workable grace period of 28 days to either delete material of an individual that was held under investigation, or apply to the Biometrics Commissioner for a continued retention period. Practical changes like these are welcome and highlights the stress testing that has taken place with the PSNI to ensure this legislation is as fit for purpose as possible. I welcome the Department recognising where tweaks can be made to ensure that legislation matches the reality of pace on the ground. We will also be supporting Amendment 108, amongst others, that make changes to Schedule 2 of the Justice Bill, which updates the terminology in the PACE order from reported to the term complaint being laid against a person. Again, a change that seeks to mitigate confusion and interpretations of the term reported in legislation, and clarifies timing regarding operational procedures across biometric provisions. Alliance will also be supporting the progression of Amendment 8 as it provides further clarity on procedure across biometric provisions. In this case, highlighting that DNA and fingerprints of an individual arrested but not charged can be retained by the PSNI until the outcome of an application made to the Biometrics Commissioner is known. Amendments 66 and 67 insert new clauses into the Justice Bill, putting in place powers to photograph a person at a police station and the power to specify a date for attendance at a police station. Alliance supports closing this gap in provision, as currently in legislation there is no power provided to the PSNI to require a person to attend a police station, even at a later stage, for a photograph to be taken, even when a photograph is considered unclear or incomplete. These provisions will allow not just for this, but for the PSNI to direct officers to take fingerprints, DNA samples and photographs on a specific date and time. These interventions will be useful in allowing the PSNI to maximise the timeframes around the detection and prevention of crimes. I will now move on to the amendments brought forward by the Committee for Justice, which will both be supported by my party. Amendment 40 puts in place a much welcome enabling power regarding the retention, use and destruction of photographs. During committee stage, there was much discussion on whether photographs or images should be included as biometric material within this bill. And if there's one thing that all of us in this chamber can agree on, that there is still much more that can be looked into in this space. Technology is evolving, both in terms of how we use it to prevent crime and how it is being used to evade detection. Heightened use, or at least consideration, of facial recognition technology is inevitable in years to come, and the evidence we receive from local authorities, but also more widely across these islands, including the Scottish Biometrics Commissioner, all pointed to this. Alliance believes that an enabling power strikes the right balance in ensuring that we can address the use of photographs in the future once more specific policy development has been taken. This amendment requires a delivery of draft regulations within 5 years, and this does feel suitable. Alliance will also support Amendment 104 from the Committee, which specifies that the Department must by order appoint a day for the coming into operation of Part 1 within 5 years of the Act receiving Royal Assent. I will now move on to the amendments that have been brought today by Sinn Féin. As the Minister has already outlined, we will be agreeing with her, and Alliance will be opposing the amendments that have been brought forward by Sinn Féin in this group. I'll raise a few particular points of concern on these, but want to emphasise that this is primarily stems from the fact that much of this will be resolved in regulations and updated PACE codes. These will both receive more time and scrutiny on them than can be afforded today. Amendments, including 11, 12 and 13, relate to a rewriting of the biometric retention schedule for those under 18. Looking at Amendment 11 specifically, this tries to remove under 18-year-olds from the scope of qualifying offences provisions, which are some of the most serious crimes a person can commit. We don't find this to be proportionate and believe that the proposed amendments would weaken the well-constructed retention and destruction regime that has been designed with the interests and rights of under 18s in mind. Amendment 35 inserts guidelines for guidance provided by the Biometrics Commissioner, including requirements for what information custody officers should provide. The Biometrics Commissioner is intended to be independent, and Alliance is of the belief that these directions could risk the independence of the Commissioner. Amendment 28 removes the 2-year retention period for penalty notices issued to adults. Alliance believes the current provisions are appropriate, particularly as it includes behaviour such as criminal damage. I was also concerned to read of the proposals that diminish and take away the role of the PSNI in the appeals process regarding biometric material. Current proposals would mean decisions could be reviewed by a different and more senior officers with no prior involvement. It is the belief of my party that disqualifying the PSNI from carrying out the appeals process is not workable or appropriate. Lastly, I wish to address Amendment 38 under Jerry Carroll's name, on the duty to provide information to persons whose biometric data is taken. It is my understanding that, similarly to some of the suggested provisions by Sinn Féin, this is to be addressed via PACE codes, subject to public consultation and Assembly scrutiny. I find it pertinent to emphasise that the new biometric retention framework will not be commenced until regulations are in place, which will still take some time. Regulations that will be subject to further public consultation and Assembly scrutiny processes. This conversation is not one that will be disappearing after this bill, but one that will probably instead be discussed more and more frequently across our justice system. So with that in mind, Alliance is proud to support the provisions that Minister Long has proposed today, and to ensure that we have a proportionate, balanced human rights approach to biometric data retention and destruction across Northern Ireland. Thank you.
Ferguson.
I welcome the opportunity to speak at consideration stage of this important bill as a member of the Justice Committee, and first I want to acknowledge and deeply thank the wide range of organisations, legal professionals and the Assembly staff for the extensive work undertaken to support the scrutiny of this proposed legislation during the prolonged committee stage. I also want to thank the young people that we engaged with who participated in a roundtable event in relation to the bill. I think it's important to acknowledge that young people and children's rights organisation, including the Children's Law Centre, the Commissioner for Children and Young People, Include Youth, VOIPIC, Bernardo's and the Youth Assembly and others have highlighted significant concerns around the existing systems dealing with children and young people within the justice system, the negative impacts of the perpetuation of a social stigma, undermining rehabilitation and the prevention of reoffending, alongside the ongoing lack of suitable bail accommodation for our children and young people here. We all have a duty, in the context of prison population pressures and the overall higher youth reoffending rate here, to assess the structural barriers to reintegration following both criminalisation and custody, in ways in which economic disparity and social alienation are driving reoffending due to unmet need and systematic exclusion, alongside how proposals will contribute to strengthening early intervention, diversion and community alternatives to detention. I therefore want to focus on a few important amendments being brought by Sinn Féin in relation to restricting the right to retain biometric data of children and young people under 18. As mentioned by my party colleague previously today, the Marper ruling in the European Court of Human Rights sets an important precedent in relation to how any blanket or indiscriminate retention must be considered in the context of proportionality and balancing the right to privacy. When it comes to the retention framework of those under 18, Sinn Féin remain seriously concerned, like many organisations whom the committee had engaged with throughout the deliberations of this bill, as drafted, goes beyond what is necessary. Whilst I note that the bill, as drafted, includes shorter retention periods for under 18s than adults, this was carried over from Schedule 2 of the Criminal Justice Act, NI 2013. It was approved, but it was never commenced 13 years ago. This is now 2026. Sinn Féin supports a stronger differentiation for the special position of children and young people than that which has been proposed, and as that, like many of the child's rights organisations have noted in our committee meetings. Whilst the Minister is suggesting a breadth of different retention periods from 5 years to 25 years for those convicted of a minor offence with custodial sentence of less than 5 years, but with a previous conviction, we want to see a similar model to that adopted by Scotland, which is set out in the Code of Practice, and it's a statutory Code of Practice in 2022, not something from 2013. And the Biometrics Commissioner, and reflected in the terms of reference for their Phase 1 thematic review of biometric data relating to children. Scotland, back in 2020, took a whole system approach to youth justice, with a focus on keeping children out of the formal justice system as far as possible, with recognition of the principles of proportionality, necessity, and the presumption of innocence. Due consideration and acknowledgement must be given to the specific risks of stigmatisation for children and young people. And I know that, Minister, you don't believe this would create stigmatisation. However, our proposals must marry with our duty to protect and uphold the best interests of a child. The Children's Law Centre clearly set out and seriously believe that this will significantly undermine the presumption of innocence and due process. The retention of records casts suspicion on young people who have been, for instance, acquitted, thus implying that they are not wholly innocent. Yes?
I mean, we've already established via a number of interventions that if somebody is acquitted, it's only in extreme circumstances where the Biometrics Commissioner judges that there is a necessity that their data will be held, because that would be in breach of human rights law. So I'm not sure why we're still repeating the myth that people who are acquitted of serious offences or any offences will continue to have their biometrics held. That is not the case.
Well, here, if we look at persons arrested for or charged with a qualifying offence, and if you look at Section 3, if P is charged with a qualifying offence but is not convicted of that offence, P's material may be retained until the end of the period of 3 years, beginning with the date in which P is charged with the offence. See also Article 63H. Yes?
And that 3-year period is to allow where somebody has not been charged, because the investigation may be ongoing. And therefore the police need a grace period during which they can hold and retain that data so that it may become pertinent at another point in their investigation. But when someone is acquitted of a crime, it is a requirement of the law that their data will be removed from the database, and only by exception, where the Biometrics Commissioner agrees that it's necessary, would the police be allowed to contain it for longer than that. This is simply to ensure that if someone is a person of interest in a criminal offence which is under investigation, are not immediately charged, but the investigation then moves forward, that their data is not having to be re-asked for, it is simply retained for a short period for 3 years, and not for an extensive one.
Ms Ferguson, whenever you give way to someone, you resume your seat.
Oh, sorry. Apologies.
No, it's okay, don't worry. But just advising, there's only ever one person standing in the seat. All right, thank you. Continue, Ms Ferguson.
Yes.
What might be helpful for this debate is that if the Minister could give examples of extremist or exceptional circumstances for which when the data would be held after the person has been deemed innocent. Thank you.
I'm happy to allow the Minister, yeah.
So, and I think the purpose of the next stage of this, which is to consult on the powers of the Biometrics Commissioner, will be the decision point at what those thresholds will be. But if you read this, including what's in the bill and the amendments to it, the purpose of that is to ensure that those who are found innocent can have their data removed quickly and effectively from the database. Those who are found guilty will have it retained in a way that they can understand, and also understand how they can appeal that decision. And where a case remains open, the PSNI retain the data but have to check it every 5 years to make sure that the case is indeed under investigation, so that data is not unnecessarily retained. It is a balance of rights, but it will ultimately come down to the Biometrics Commissioner deciding that a case is so exceptional that it requires a deviation from what is set out.
Can I thank the Minister for your intervention, but I'm not going to rest the case. This is not Sinn Féin saying this regarding the stigma of our young people and the impact and the negative impact it will have on our young people. This is all children's rights organisations who have came to the committee and said it quite clearly, the impact that it will have on our young people. In Scotland, biometric data for those under the age of 18 is only captured and retained for those arrested for violent or sexual offences or otherwise by exception. Since the adoption of this model in 2024, there has been a significant decrease in the number of children who have had their biometric data retained. This Assembly should, in the strong view of our party, apply equal caution to the creation of any system in which children who have committed minor offences, or indeed who have had not been convicted at all, risk having their biometric data retained by the state. We would support a similar approach to Scotland, whereby a child's data can be retained for 3 years for qualifying offences which are considered to be the most serious recordable offences which represent the greatest harm to society, unless the police apply for and are subsequently granted an extension by a court of 2 further years. And as my colleague noted, and in relation to Paul and your question earlier, these extensions can be granted repeatedly. There is no maximum to that. Importantly, there should be strong justification for any prolonged retention for children's biometric data, and the risks associated with the processing must be recognised, assessed and managed. For less serious offences and where grounds are not established, there should be no data retention in relation to children. The presumption of innocence is a fundamental principle of our justice system. So arguing for data retention on the basis of investigating future crime is a highly contested human right issue. We support a position which mandates children's rights to be actively evaluated during all ongoing biometric storage assessments, for children to be adequately informed in a manner understandable to them, and for suitable opportunities provided for children to verify the deletion of their personal data. Given a wealth of evidence which demonstrates the crimogenic stigma and negative impact on children's life chances arising from contact with the criminal justice system, Sinn Féin believes we must seriously consider the extent to which any measures proposed may result in undue stigmatisation or reduced opportunity for genuine reintegration. Significant reform is needed right across our justice system to make it more efficient, transparent and worthy of public confidence. Whilst it must be victim-centred and capable of delivering community safety and public confidence, it must also be rooted in respect for human rights in all of its undertakings. Our proposals are reflected in Amendments 11 to 13 and 23 to 24, and I would therefore conclude my remarks by encouraging all members in this House to support these amendments today. Thank you.
Kingston.
Thank you, Mr. Speaker. And I rise as a DUP member of the Committee for Justice since joining last September. This Justice Bill certainly is wide-ranging. My colleague Paul Frew reminded us that he called the original bill a half a bill due to the number of clauses and topics that were not ready when it was published by the Justice Minister. Paul also pointed out that the pack of amendments that we have received is thicker than the original bill, but he also agreed that he was responsible for some of those amendments. So the many additions to this bill has been challenging for the committee to ensure proper scrutiny and evidence gathering during the committee stage, as some topics were notified to us without the actual proposed wording, and indeed some ultimately did not proceed. The amendments we are debating now in Group 1 relate to Part 1 of the bill on rules for the retention of biometric data, including fingerprints and DNA profiles. It also includes committee amendments relating to the retention of photographs, which the committee agreed should be included. The time limit for the retention of biometric data in various circumstances can be 2 years, 3 years, 5 years, 25 years, 50 years and 75 years. I think we can all accept the need for a range of retention periods, a shorter period in the case of those arrested but not yet charged or convicted, and at the top end of the scale for those convicted of recordable offences which carry a potential prison sentence, including the most serious offences. Clearly there are a range of views in the Chamber on the amendments on the detail of this. We have amendments from the Minister and individual MLAs, and some agreed by the full committee. Some of the amendments are from Sinn Féin, and I do note their newfound interest in the retention of biometric data. This contrasts to their position on the 23rd of September 1992, when the IRA exploded a £3,000 van bomb outside the Northern Ireland Forensic Science Laboratory at Beaver in Belfast and attempted to destroy evidence in terrorism cases. I was at football training at Olympia Leisure Centre on the Boucher Road that evening, and I recall well the sound of that massive explosion echoing around the city. Over 1,000 homes in Newton Breda were damaged by that bomb, and many people were injured, but no doubt Sinn Féin will tell us that there was no alternative to that. There certainly was an alternative, and nearly 34 years later, here we are in the Northern Ireland Assembly discussing amendments from Sinn Féin and other parties to ensure the retention of biometric matter to help convict those responsible for crimes, including terrorism as occurred on that night in 1992. On the Committee for Justice, we identified a particular need to include a clause on the retention, use and destruction of photographs, and we were able to reach agreement on that as Amendment 40. I note that there are also various amendments to PACE codes contained in the Police and Criminal Evidence Northern Ireland Order 1989, most of which have been tabled by the Minister in relation to the power to photograph certain persons at a police station and the power to specify a date of attendance at a police station for fingerprinting, etc. So, in conclusion, I welcome that the bill has finally reached this consideration stage so that we can determine the Assembly's position on the 132 amendments which have been tabled to the bill. Thank you.
So Finnegan.
And I would like to reference that in 1992 I was 4, so yes. Anyway, Sinn Féin supports the introduction of a new biometric data framework because we believe the retention of biometric data must always be based on clear principles of necessity, proportionality and justification. I just want to take a moment to focus on the issue of photographs. The absence of a framework for the retention, use and deletion of photographs is a glaring omission and one that needs rectified urgently. So I'm pleased therefore to support Amendment 40, which provides the Department with a time-limited regulation making power to introduce a new framework for photographs. Whilst this bill is primarily to remedy just judgments in the European Court of Human Rights, it is vitally important that we future-proof the legislation in a way that takes account of the emerging technologies. The rollout of AI and facial recognition technologies in the South, in Britain and across Europe is a development that all of us must keep a close eye on due to the risk of misuse, miscarriages of justice due to unproven technology. We know that with AI in particular, it is only as good as the data they are trained on. If historical policing data reflects bias, AI can reinforce those patterns rather than correct them. There is a real risk that AI can be extended to facial recognition technology, which then, when processed, becomes biometric material for police services. It is not sustainable and is to not have a legal framework for dealing with this material. Photographs are no longer just photographs. In an increasingly digital world with increasing surveillance, photographs are a key biometric identifier that can be shared across borders and international law enforcement agencies. And it is vital that proportionate safeguards are put in place to curtail potential abuses of this data. I welcome the committee's scrutiny of this matter and I'm pleased to support the committee's amendment, and I welcome the Minister's comments earlier today to Mr Frew because whilst the committee amendment states that regulation must introduce within the 5 years, I would encourage the Minister to get to act with urgency and to introduce a new photographs framework as quickly as she can, and I know that you have agreed to that today. If it can be done quicker than 5 years, I'm sure all MLAs would welcome the opportunity to scrutinise and implement it as soon as possible. I also want to quickly touch on some of Sinn Féin's amendments on biometrics. We have concerns raised that the data of children and young people should be retained because of the potential risk of reoffending, and my colleague has outlined that. However, our position is clear. We have learned from other jurisdictions that positive outcomes can be achieved without unnecessarily stigmatising young people. Our amendment would still allow for the retention of biometric data where an individual has been convicted of a qualifying offence or an expected offence. What we oppose is the automatic retention of sensitive personal data without sufficient justification. The Minister has pointed to reduced retention periods for under 18s. While that is welcome, we do believe it goes far enough. We support a model similar to that operating in Scotland, where retention beyond the initial period must be justified and approved in exceptional circumstances. We've also heard arguments that data should be retained where a person has not been convicted but where concerns remain about their behaviour. We must be careful here. The starting point of any democratic justice system is the presumption of innocence. If an individual has not been convicted, any interference with their privacy rights must be deemed to be necessary and proportionate. Biometric information is a deeply personal and sensitive data, and it must be treated accordingly. And finally, while the bill proposes review and appeal mechanisms, those arrangements have yet to be fully developed or scrutinised. So Sinn Féin believes there must be genuinely independent oversight of retention decisions. The Biometrics Commissioner should have a stronger case handling role and sufficient powers to ensure public confidence in the system. At its core, this debate is about striking the right balance between public safety and individual rights. We believe these amendments achieve that balance, and for those reasons, Sinn Féin will support them.
Morris Bradley.
The more people that spoke, the more pages I folded up and put in my wee book. So thank you very much. But listen, I suppose as a member of the Justice Committee, I welcome the opportunity to contribute to the debate on this group of amendments relating to the biometric data, police photographs and the wider framework governing the retention of personal information by law enforcement agencies. And I recognise the input from the Minister and her department throughout the amendments to the bill. The issues before us today engage some of the most important principles within our justice system. On the one hand, there is legitimate expectation that police and prosecuting authorities have access to the tools necessary to prevent crime, protect the public and bring offenders to justice. On the other hand, there is an equally important obligation to ensure that the collection, retention and use of personal information is proportionate, transparent and consistent with individual rights and freedoms. Throughout the Committee's consideration of the bill, evidence repeatedly highlighted the need to strike the correct balance between those competing interests. Public confidence depends not only on effective policing, but also upon the existence of clear safeguards, independent oversight and public accountability. Many of the amendments in this group are technical, consequential and designed to improve the operation of the legislative framework. Others raise more substantive questions regarding the retention of biometric material relating to children and young people, the role of independent oversight, the treatment of restorative justice outcomes, rights of notification and appeal, and the future regulation of police photographs. As members consider these amendments, I believe several key questions should guide our deliberations. Does the framework support effective policing and public protection? Does it provide appropriate safeguards against unnecessary retention? Does it recognise the interests of victims as well as the rights of individuals? And ultimately, will it command the confidence of the public who we are here to serve? These are not straightforward issues, nor should they be approached in a simplistic manner. The House must seek a balanced and workable framework that protects both public safety and fundamental rights. At a time when policing faces increasing challenges from serious organised crime, paramilitary activity and emerging technological threats, it is essential that we do not inadvertently weaken the legitimate investigative tools available to the PSNI. Equally, where the state retains highly sensitive personal information, there must be a clear safeguard, robust oversight and public accountability. The challenge before the House is to ensure that both objectives are achieved. And with those considerations in mind, I would like to address Amendment 40, which is very important at the time, and also confess that I have a digital archive going back to 2005, a digital and negative archive going back to 1972, and a personal archive going back to the late 1800s. So I am aware of how archives work. Amendment 40 addresses an issue that has attracted increasing attention in recent years, namely the retention, the use, the destruction of photographs held by enforcement agencies. Given developments in technology and the growing public concerns surrounding privacy and data protection, it is reasonable that a clear statutory framework should be developed. I welcome consultation with key bodies, including the Information Commissioner, the Human Rights Commission and the Justice Committee. Any future framework must strike the correct balance between protecting privacy rights and ensuring that law enforcement agencies retain the tools necessary to investigate crime and protect the public. It is particularly important that any regulations are workable in practice and do not unintentionally hinder legitimate policing activity. Overall, these amendments engage important questions concerning transparency, oversight, public protection and confidence in the justice system. As with all amendments, the challenge before the House is to ensure that the appropriate safeguards exist while preserving the operational effectiveness of the PSNI and maintaining a strong focus on victims and public safety. Whilst I support the principle of greater clarity around the retention and use of photographs, we must ensure that any future regulatory framework does not become so restrictive that it limits the ability of the PSNI to properly investigate crime. The public expect robust safeguards, but they also expect the police to have the tools necessary to identify offenders, protect victims and keep communities safe. I will look forward to the continuing debate of the Justice Bill and its various amendments throughout the Assembly. Thank you, Mr. Speaker.
I call the Minister to wind. Sorry.
I knew you wouldn't have forgot about me. A lot of technical amendments, obviously, in this, but also a lot of important issues that members have addressed. I'm not on the committee, but obviously is my right, as other MLAs' right is, to submit amendments, and I'm sure that the committee members will keep me right when I slightly stray off. So this part of the bill is about some of the most important fundamental justice questions we have, Mr. Speaker. How much of the state gets to keep, and for how long, when you've done nothing wrong in many cases. And we're obviously only debating an end to an indefinite retention of people's DNA and fingerprints, because, as members have stated, the state was dragged into it not once but twice by the ECHR. Holding people's biometric data indefinitely breaches Article 8 of the Convention, and for the best part of 2 decades, people's rights here have been breached, and the courts have said so plainly, and successive ministers have sat on their hands on that time. So definitely we should welcome the move away from blanket indefinite retention, but this is only the bare minimum, in my view, required to stop breaking the law arriving years later. This bill, obviously, as members have stated, replaces a keep it forever model with a 70, 50, 25-year model. 75 years for most people is their entire adult life, and for huge numbers of people, that's just indefinite retention by another name. And the experts, I believe, who came to the committee said as much. We should be moving towards a genuine proportionality model. So I'd ask the Minister, and I'm happy to give way, where is the proportionality here? Why is it 75? Yep. Why is it 75 years and not a model tied to the actual seriousness of the offence and the evidence on reoffending on a case-by-case basis? Happy to give way.
Is tied to the seriousness of the offence, because the 75 years is for serious offending and adult offending, so that's the first thing to say. Second thing is that it is proportionate, because there are opportunities for people to be able to seek a review of whether or not their data should continue to be held, and they have that opportunity to go to the Biometrics Commissioner and request that it be reviewed. So I think that gives it the proportionality. From our perspective, it's not our interpretation, it's certainly not the advice that we have. Indefinite retention means the period of retention is not defined, and also where people are not able to challenge whether or not that can continue to be held. And that definition, I have to say, is supported by the European Court of Human Rights in the Cochrane judgment itself, because the UK argued that their indefinite retention was similar to other member states which had long retention periods, and the EU Court of Human Rights ruled otherwise.
Thank you, Minister, for that. I suggest a case-by-case basis is a better format, and 75 years is indefinite retention by another frame. But I appreciate. Yeah, go ahead. Yeah.
Well, of course, as I said, a case-by-case basis is neither practical nor does it give people sight at the point where their data is taken for how long it will be retained under different circumstances. This gives clarity and certainty, but it also means that people are able to, it will be subject to a review at a certain period of time. They are maximum retention periods, and the review means that if that material is reviewed and is no longer necessary for a policing purpose, it can then be deleted. So these are maximum retention periods, and it is important to distinguish that from saying that these are standard.
I appreciate that, Minister. I still don't understand why it's not practical, but I'll move on. Yeah, give way, sure, yeah.
Giving way on this, because it is a very important issue. The member states very clearly that 75 years is a very long time, so it is. But if he doesn't like the 75, 50 and 25 model, and he wants to go to a case-by-case basis, how would that ever stand up with regards to challenge? And how would you ever put a framework in place on a case-by-case framework?
Fair enough question. I think that I'll come to the member in a second. I mean, I think that the reason why I'm asking it of the Minister is obviously she's drafted the bill, she's got resources to kind of put that in place. She's obviously taken a different perspective, which is her entitlement, so that's the reason why I've posed the question. Give the way to the member for East Derry.
Member for giving way, and I think it's just important to note that we have advice from the Human Rights Commission, who have condemned it that the 75-50-25 model is too broadly constituted, disproportionate, and is not compatible with Article 8, and I think that should be the standard to which we set ourselves.
Members for intervening and agree with that. I'll move on slightly. Mr. Speaker, excessive data retention periods, as we've heard, have a particularly harmful effect on young people. They do stigmatise young people, despite what the Minister did say earlier. And I would ask the Minister if she was serious about strengthening children's rights. The state shouldn't be powered and enabled to build a database that holds on to information, not exclusively, but primarily information relating to working class teenagers' DNA for 50 years over either a mistake or a non-serious or less serious crime. And I thank the members for Sinn Féin for raising these points and their amendments. I'll go in a second. And their amendments in this regard, they replace obviously the original long, fixed and stigmatising data retention periods for children with a short review-gated model, which is a better approach, the right approach, one rooted in children's rights and protection. Not my words on this page, but the view of many human rights organisations and civil rights organisations, I believe, addressed the committee. Minister, yeah?
Back to the 50-year retention period, it is for serious offending and indeed for repeat offending. So it's not as simple as saying that this is for all offending. Actually, the standard retention periods for young people are shorter, but also it's accompanied by an earlier review point in the system to ensure that where young people go on, as we would all hope they would do, and as the Youth Justice Agency very effectively ensures the majority of our young people who offend are able to, that they're able to move on and have that data removed from the database. So this is about checks and balances. There is no one right system. That was also made clear by the Biometrics Commissioner for Scotland, who said that there are a number of models that fit with the rules of the ECHR, not a single model, and there is no gold standard anywhere for this. There are a variety of models. This is one, but it also is geared towards ensuring that children are given special dispensation, as is right.
Also, serious concerns, Mr. Speaker, around the provisions around police photographs, and I hope the Minister or the Chair can maybe come in as I raise some issues. The Minister's amendments, the new clause and the new schedule give the police a power to take photographs and to compel people to return to a station at a specified date and time to be photographed, fingerprinted and sampled, and this is obviously being presented as a operational fix, putting photographs on the same footing as DNA and fingerprints. But second and far more significant is the committee's amendment creating an enabling power, a power for the department to bring in by regulation a whole framework for the retention and use of police photographs within 5 years. And the committee acknowledged this is being done because the policy work and the public consultation has not been undertaken. And I'd have some concerns about this, regardless of who the Minister is now or who the Minister would be in the future. What does a framework for the retention and use of photographs mean in 2026? It means a facial image database. Facial images are the raw material of facial recognition of biometric surveillance. And it seems we're being asked to hand the department a blank cheque by regulation with a fraction of the scrutiny that primary legislation gets on a matter that goes to the heart of everyone's privacy. Happy to give way to the Chair, yeah.
So, lest there be any misunderstanding in this regard, the same reason why the Minister is bringing a bill to put a structure in place for biometrics, we feel in the committee that it would be right to have a framework in place that we could all judge, we could all look at, we could all see and understand around photographs too. So if you like, what the committee is trying to do is include the photographs into that biometrics framework, which then you will know and everyone else will know and the public will know exactly how long that image of them will be in the system before it's destroyed. So I think that's really important, especially when he talks about the advancement of photographs and images with regards all the other technical and digital side of things?
I think the Chair began to make it, Minister, yeah.
And I think generally people have been with their time, which is good, because I think it's better that we have these open exchanges. The purpose of this being brought within, I mean, the reason the department didn't put it on the face of the bill is because the work hadn't been done. In terms of bottoming this out, there was work to be done by the Home Office and others, and so the department felt it wasn't the right time to do it. The committee, however, I think correctly on this occasion felt that creating an enabling power that would allow the department to do this, given the pace of change, would allow us then to go forward. But to be clear, there will be public consultation as part of that. It will be done by regulation, but it will come to this House, and it will be by affirmative procedure. So we're not there to stifle people's ability to scrutinise that, because I recognise it's important. The issues around the use that those photographs are put to is a separate issue from their retention and how they're handled, and that will also have to be dealt with, no doubt, in short order around AI usage, for example, facial recognition software and so on. But that's a separate issue to the retention, which is what this deals with. So if the member is concerned about those issues, there will be other opportunities to deal with those.
And the Chair for that. And moving on, just on the position of Commissioner for the retention of biometric material, I'd ask the Minister, I think one of the members opposite were raising this question about the independence from the Department and the PSNI, and if I heard correctly, the Minister has power to appoint the Commissioner. Did I pick that up correctly? Yeah? Yeah.
First of all, the Commissioner, yes, has to be appointed. The Commissioner will also have to provide a report to the Department, but that report will be a purely factual report on the operations of the Commissioner during that previous year, and it will be laid in the Assembly. There will be no opportunity for the Minister to interfere with the operations of the Commissioner, but it will give the accountability that the members opposite were saying they want, and that the report will be laid in front of the Assembly, and they will be then free to take up any concerns or issues that they have with the Commissioner.
I think the concern about independence still remains, but I appreciate that information. I also would ask the question about whether they will be given the remit to keep the whole retention regime, including looking at future photographs and facial recognition framework under meaningful review. The committee was right, in my view, to be alarmed that Part 1 initially had no commencement, or currently does a no commencement time frame, and the sort of 5-year backstop, and every day the old indefinite regime stays in force is another day the state is doing to people exactly what the courts told it to stop doing. And I'd press the Minister obviously to move at speed at this. So in summary, Mr Speaker, I'll be, and my party will be supporting moving away from indefinite retention, because the current law is an ongoing breach of people's rights, and that has to end. But we have serious concerns that the photographs power is a surveillance framework being smuggled in through the back door with the promise to fill in the detail later. Chair.
Giving way. Just before he stops, can I ask him just for clarification? So when he talks about a case-by-case basis, does he mean certain crimes, murder compared to manslaughter, or does he mean certain crimes where there's been 2 people murdered as opposed to just 1 person murdered? How many culprits are involved? Can he explain to me what he would use as a measuring tool when designing a case-by-case model for the retention of biometrics?
I think a case-by-case model is the preferred model, and the current one is too blanket. So obviously, I think the Minister should be maybe looking at a case-by-case model to explore what the best options are. Obviously, so I think it's a better preferred model in a general sense, rather than me giving a prescriptive model just on my feet here. And just to move on to number 38, my own amendment is based on a quite simple idea. That is, if the state is going to take a person's DNA or fingerprints or hold it on a police database for years or decades, then the least they can do is tell that person the truth about what it is doing. This amendment simply says that when your biometric material is taken, you're handed in writing 5 plain facts, not groundbreaking here, but it is facts to say the legal basis on which your data is taken, how long it can be kept, when it must be destroyed, what your rights are, how you can go to find out more about it. It also says that if any Any of that changes, and later, if the clock on your retention period is reset because you are charged or convicted, or because a national security determination is made, then you're told in writing as soon as possible. And today we're rightly debating amendments to give people a right to review their retained material, a right to ask for confirmation that their data has been destroyed. They're obviously welcome and important amendments. But I'd say to members, a right you've never been told about isn't really a right in anybody's definition. You can't appeal a decision you don't know was taken. You can't ask for your DNA to be deleted if you do not know it is still being held. Amendment 38 makes all of those other protections actually work, because it puts the information in the hands of the citizen rather than leaving it locked inside a PSNI computer or a database somewhere. The presumption of innocence should at the very least mean that an innocent person is told that the state is holding their DNA and why. Working class communities that have lived under the eye of the state for generations know exactly what it's like to be watched, stopped, photographed and recorded. For people that I represent in West Belfast, the principle that you have a right to know what the state holds on you is extremely important indeed. And I think this is the bare minimum a person is owed, Mr. Speaker, when the state takes their body, parts of it, and keeps it. And I ask all members to support the amendment for that reason. I'd like to just return to the Minister's questions earlier about my own amendment. From my understanding, the Minister's intervention said that this will be covered in the PACE code. If she and other members have no issue with the principle of the amendment and the intent behind the amendment, then there should be no issue with putting it through, putting it on the bill. Happy away, yeah.
Was the second part of the amendment would be dealt with through PACE codes. The first part of the amendment is not within the competence of this Assembly because it relates to terrorism offences and other measures that are reserved, and therefore you cannot pass one part of the amendment without passing both parts, and that's why I'm suggesting that members resist that amendment, but offering you the reassurance that we're not actually opposed in terms of what you're trying to achieve in the PACE codes actually being taken up.
Minister, but I would say respectfully, I think it's not the Minister's role to say whether amendments are legislatively competent or not, and I think this one is, and I would, it's your opinion, it's fair enough, but there's a change at desk here, so there's an opportunity to put data transparency and accountability on the face of this bill, rather than waiting years, and this is a concern that I would have, waiting years for the PACE codes of practice to be updated if they eventually do be at all. And people who agree with these principles and stand by them should vote for the amendment. And regarding the possibility again of legislative incompetence, I dispute the Minister's assertion that it is not competent. But this amendment is about the responsible officer providing written notice when a national security determination status changes. It's not about changing that status or interfering with reserved matters. It's about responding to changes in status with relevant written information. That's what's stated in the amendment, and I would urge members to back that amendment. Thank you, Deputy Speaker.
Thanks, Jerry. I now call on the Minister for Justice to wind on this group. Thank you.
Thank you, Madam Principal Deputy Speaker, and I'm very encouraged by the engagement that we've had today. I think it was a good debate with a good exchange of views, and I want to thank everyone who contributed to this, and I think it was very helpful. Just at the outset, as comment was passed on the extent to which the bill has been amended, I think that was well rehearsed at second reading, and we had the conversation about it. I say again, there are reasons why there are so many amendments. 2.5 years of a suspension and a limited mandate on coming back meant that we needed to get the bill introduced. We had a 1.5 years in committee, and many things have emerged during that period which weren't expected. And therefore it is important that we're able to respond, because this will be the only wide vehicle that will be available in this mandate in order to make changes to justice matters, sentencing and victims and witnesses being much more constrained in scope. In terms of biometrics, however, which is this group that we're debating, they were on the face of the bill at introduction. The amendments that are being made are to make them operate as intended after that stress testing we did. And of course, under normal circumstances, that stress testing would be done before we introduced them. But I would caution members against voting for individual amendments to that regime that have not been stress tested with operational partners. given that even though the department had developed these over a number of years, stress tested them with partners and then had to come forward with further amendments, to change the bill at this stage without having done that due diligence, I think endangers what we're trying to achieve, however well-intentioned those amendments may be. With respect to the background to... I will, yes.
Because she does raise a very important point, and it alludes to the fact that I said earlier, that it's the Department and the Minister who has adopted this model, who have plumped for this model, rightly or wrongly, and she has said, and I have said, there's no gold standards and there's no system perfect. And I think she is right in what she says, where we as members would start to cherry pick that structure. Because I looked at it and I struggled to see where I could make changes that I could be convinced would make it better, both in the balance between human rights and also with regards to enforcement of law. Thank you.
I appreciate that. And that is, I think, the point that I wish to make. In terms of the background to this part of the bill on biometrics, a number of members have mentioned the issue about the Cochrane and Marper judgments. In S and Marper versus the UK, the court held that the holding of biometric material of non-convicted individuals is a violation of the right of a person's right to respect for their private life under Article 8 of the Convention. So that's what this is designed to address. In Cochrane, the court held that the indefinite retention of biometric material of persons convicted of an offence, punishable by imprisonment without reference to the seriousness of the offence, and in the absence of any real possibility of a review, was a breach of a person's right to respect for their private life under Article 8 of the Convention. They also were helpful in the judgment as they gave guidance as to how a compliant retention framework in the UK might be structured. And based on that, it appears that the way we do that is to ensure that any new retention framework takes account of the seriousness of the offence and any continuing need to retain the biometric material for policing and criminal reasons. B, a review process should be in place to allow individuals to request deletion of their material, including taking into account possible changes in their personality and presumably their likelihood of further offending. And then it should take into account the age of the person when he or she was convicted and the length of time between the offence and the end of the retention period. Now, I believe that the new 75-50-25 retention framework, along with the new review process, address those findings in full. I am not saying that it is the only model available. There are other models available. People have made reference, for example, to the Scottish model, though I would caution members the Scottish legal system is quite different to our own. So, for example, you have cases that are determined where somebody is proven not just innocent or guilty, but where it's not proven. We don't have that judgment here, and they would take a different approach when it comes to retention of data in those circumstances. So a simply lift and transpose arrangement is not necessarily best. The 75-50-25 model was developed following consideration of the Sunita Mason Review of Criminal Records in Northern Ireland, which recommended a criminal record information should be kept until the subject reaches the age of 100. There is limited information available for retention regimes across Europe, but there is certainly no standout country that would set the standard for good practice. As a part of the policy development in 2020, the Department considered the 2014 report by Christina Reid and Denise Sandercombe Court entitled A Comparative Audit of Legislative Frameworks within the EU for the Collection, Retention and Use of Forensic Data Profiles. That sets out that Estonia, Finland and Luxembourg hold biometric data until the offender dies, and they also factor in various timelines for retention after death. Slovakia and Latvia hold material for at least 75 years. Denmark holds material until the offender reaches the age of 80. The Netherlands retain DNA profiles of convicted individuals for 20, 30, 50 or 80 years, depending on the seriousness of the offence and the conviction. And again, I believe that whilst all of those were possible models for us to consider, the one that we did consider, the one that we did human rights proof, the one that we did take legal advice on, the one that we did stress test with operational partners was the 75, 50, 25 retention periods, and then including with that a review mechanism. That reflects the guidance that we have from the court and takes into account good practice from the various frameworks across Europe without being slavish in our following of them. It also removes indefinite retention. It has different retention periods for minor recordable offences and more serious qualifying offences, and means a reduction in retention periods for those convicted of less serious crimes and for children, all of which I think we are agreed upon as good practice. I believe the proposals strike an appropriate balance between Article 2 and Article 8 Convention rights, engage in the issue of DNA profiles and fingerprinting, and balance properly the protection of the public and the ability to investigate crime, and also the human rights of the individual. I have no doubt whatsoever that when members came to the Chamber with other amendments to the bill, that they did so in good faith and with good intent. And while we understand the intention behind them, I cannot agree and support them. And I would suggest that if the committee were unable to agree a series of amendments collectively over the last 18 months that could have been tested more fully in cooperation with the Department, it would be unwise to make those changes at this stage, as it could change or make unworkable or indefensible the regime which has very carefully balanced those rights that we put before you today. On the issue that has been raised around the independence of the Commissioner, to be clear, they will be absolutely independent in the discharge of their duties. I often stand here and am criticised and scorned because I say that that is an operational matter for whichever body it may be. Because it is important that when people are there to provide public confidence and they have an independent role, that we do not politically meddle in their independence. And so it must be with the Biometrics Commissioner, nor will they be answerable to the PSNI. Quite the contrary. The only reporting that is required is as for any sponsorship arrangement between a department and a commissioner. They will submit an annual factual report on the exercise of their functions to DOJ, and that will be laid before the Assembly for your information and scrutiny. That does not compromise their independence whatsoever, and they are not accountable to the police, nor could they be so. With regards to the issue of age, and there has been much said about age, and there will be much said about age in the days to come as we look at ages, for example, minimum age of criminal responsibility. But the stats from NISRA show that a greater proportion of youths compared to adults go on to reoffend. Since 2010 and 2011, the rate of reoffending has also generally been higher for those who committed their first recorded offence in their early teenage years. This steadily declines as age increases. Those are the statistics that we need to look at. There is therefore a need to retain material for a period of time regarding under 18s, both to assist with solving future crime and to act as a deterrent against future offending. It is part of the reason why we desperately try to do early intervention with our young people to keep them away from the justice system, because once they enter the formal justice system, there are long-term consequences, of which this is a necessary one. The specific special arrangements for under 18, which are lower than adults, are as follows. An under 18 convicted of a first minor offence and sentence other than custodial is 5 years. The vast majority of young people under 18 are not held in custody. The vast majority, particularly under 14, are dispensed with by ways of other alternatives, and indeed there is an increase in the use of non-custodial disposals for those between 14 and 18. So if it's other than custody, 5 years. An under 18 convicted of a first minor offence and a custodial sentence less than 5 years is 5 years plus the length of their custody. So it's 5 years, the same as if it wasn't a custodial sentence, plus the length of the sentence. An under 18 convicted of a minor offence with a custodial sentence of less than 5 years, but who has a previous conviction, it then moves to 25 years because they are a repeat offender. And it is logical and proportionate to do so, because if somebody has reoffended, then their data and their DNA may be more useful in future cases if they have a propensity to reoffend. Where it is their first offence, there is no establishment or no presumption that they will go on to reoffend. Under 18 cautions, including a restorative caution or informed warning, again 5 years. Under 18 diversionary youth conference, 5 years. It's also important to note that there are special considerations given to under 18s with the review mechanism, and that will be subject again to consultation, so that we can look at how we ensure that our under 18s, which can include quite serious offences in some cases, but how we ensure that under 18s are not unnecessarily criminalised. That is something that I believe in, and I have defended the work of the Youth Justice Agency at this dispatch box many times over the years. I think that the work that they do to divert young people away from offending, away from interaction with the police and the justice system, away from negative engagement in their own communities is absolutely important, it's vital, and it is excellent work. And so none of us want to unpick that. But equally, if someone is repeatedly offending as an under 18, that has to be taken into account in how long their DNA profile can be held at the maximum. It doesn't mean that if that young person grows up and applies for a review of that because they have settled and are a different person, that would be refused. The next issue I want to move on to is the issue around photographs, about which much has been said. Part 1 of the bill was focusing solely on DNA and fingerprints because the immediate priority for the department is to address the compliance issues arising from the amendments to PSNI made in the Criminal Justice Act 2013, which were never commenced and which related solely to DNA and fingerprints. The retention and use of photographs is a more complex issue, and it is important that it is given sufficient time for proper stakeholder engagement and full public consultation. And I agree with the member for West Belfast in that regard. I am, however, content with the proposed committee amendment, which will enable officials to take forward essential work in this area, informed by developments elsewhere, including any emerging legislation and technological advances. The Department will work to have the regulations in place for commencement at the same time as the legislation covering the retention of fingerprints and DNA. It is important to recognise that there is work ongoing at the moment in the Home Office with respect to images and how they will be held. And it is useful for us to be consistent, because people may be arrested for different offences, some of which fall within the devolved legislative framework and some of which do not. And it's important that people understand clearly and that there are comparators that they can draw on for how their photographs may be used and how long they may be retained. I'm also content with the proposed committee amendment regarding commencement arrangements. So in terms of committee arrangements, they have said 5 years. Just to be clear, part of the issue with the commencement arrangements of this is that there is considerable work which needs to be done. We need a qualifying offences amendment order, prescribed circumstances regulations, review mechanism regulations, PACE Northern Ireland Code D revision order with a revised PACE Code D, and a PSNI application order. We need sufficient time to consult on those measures, draft legislation and progress each instrument through the Justice Committee and the Assembly's affirmative resolution procedure, and it will be an affirmative resolution procedure. In parallel, the Home Office are required to bring forward legislation on accepted matters, including arrangements for national security determinations. This accepted legislation, to which the member refers in his amendment, is something that we cannot legislate on in this House, and I know that he has taken issue with me saying it isn't within our legislative competence, but it isn't, and we haven't sought permission of the Home Secretary to be able to legislate on it today. We cannot legislate on reserved or accepted matters. That is recognised. So we will need to work with the Home Office and coordinate and commence it alongside our new retention framework. The PSNI also require time to develop and test and implement software systems to support the new framework, and that will include testing with other criminal justice organisations, for example such as Causeway and Forensic Science NI. So we believe that the committee's commencement arrangements as proposed would work, that we would be able to meet with those, and if we can move more quickly, we will do so. However, much of this work is both substantial and lies out with the responsibility of my department. We intend to commence the new framework as soon as is practical. With respect to issues in Jerry Carroll's amendment, and to clarify, as I said at the outset, Amendment 38 includes provision for individuals that they should receive written notification when their retention period changes as a result of the making, removal or expiry of a national security determination. NSDs are not within our competence. They lie within the reserved space, and the UK Biometrics Commissioner has responsibility for their oversight. And therefore it is not possible for us to amend the Protection of Freedoms Act 2012, which is an act of the UK Government, and therefore paragraph 2C of Amendment 38 is outside the competence of this Assembly. Yes, I will.
Would you agree with me, though, what's stated in the amendment is not about changing that national security determination itself, but it's notifying an individual of when that changes, and if that is not within the competence of this House, then all the comments about policing and justice being devolved, really, there would be massive questions about how far that is devolved if we can't make a simple amendment in that regard. Thank you.
Well, I mean, we know how far justice has been devolved, and it doesn't include terrorism. It doesn't. So, I mean, we already know that, and that was the case at devolution and has been ever since, and that is recognised. We would not have the oversight, our Biometrics Commissioner would not have the oversight of these NSDs. So how would we inform people about changes to their NSD if we're not in charge of that and our Biometrics Commissioner would have no oversight of it? The UK Biometrics Commissioner is the one who has responsibility for that, and they're the one who would have to do what you suggest in terms of notifying anyone of change. And I cannot impose a duty on the UK Government. So we are talking across purposes. I want to say to the member, however, the amendment also contains some issues that are within the competence of this Assembly and to which I don't primarily object, but they are more appropriately addressed through updates to the PACE Code D. That will be subject to public consultation, and then the revised code will be introduced alongside the new retention framework. So whilst I have some sympathy with what the member is trying to do, it is not something that I can support today. In terms of the wider debate, Madam Principal Deputy Speaker, I hope that I have been able to offer the reassurances that people have sought. There was a question asked of me about the role of the Biometrics Commissioner in terms of their reporting and scrutiny. And to say that in terms of awareness raising, because this is key, where people are saying, well, how can you exercise a right you don't know you have? Part of the role of the Biometrics Commissioner will be to raise awareness of the biometrics structures that we're placing on statute. And that will be part of their role. And secondly, I was asked directly if the Biometrics Commissioner would be able to make recommendations, suggestions and report on the operability and effectiveness of what we pass, should we pass something today. And the answer to that is yes, they would. And it would then be incumbent on the department to consider those recommendations and the feedback on that. And that would form part of the annual report, which will be led in this House, which will give members around the chamber the opportunity, if they so wish, to come back and seek further changes in future in primary legislation to what we're proposing here today. So with that said, Madam Principal Deputy Speaker, I draw my remarks to a close.
Thank you, Minister. Okay, so I suppose fasten your seatbelts here. There's quite a lot of votes to get through. So, amendment to Clause 1, page 3, line 15, leave out and insert the words as printed on the Marshall list. So the question is that Amendment 1 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. The ayes have it. Amendment 2 has already been debated and is paving Amendments 3 and 4, paving for Amendments 3 and 4. So I call on the Minister of Justice to formally move Amendment 2.
So moved.
Thank you, Minister. So amendment proposed to Clause 1, page 3, leave out line 21. So the question is that Amendment 2 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. The ayes have it. Amendment 3 has already been debated. I call on the Minister of Justice to formally move Amendment 3.
So moved.
Thank you, Minister. The amendment proposed to Clause 1, page 3, line 22, insert words as printed on the Marshall list. So the question is that Amendment 3 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. The ayes have it. Amendment 4 has already been debated. I call on the Minister of Justice to move formally Amendment 4.
So moved.
Thank you, Minister. So, amendment proposed to Clause 1, page 3, leave out lines 27 to 32. The question is that Amendment 4 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. The ayes have it. Amendment 5 has already been debated. I call on Emma Sheeran to move formally Amendment 5, which is mutually exclusive with Amendment 6.
Bugha moved.
Thank you, Emma. Amendment proposed to Clause 1, page 4, leave out from line 9 to line 15 on page 6. So the question is that Amendment 5 be made. All those in favour say aye. Aye. Contrary of any noes? No. Okay. Clear the lobbies. The question will be put in 3 minutes. Thank you. Order, members. Order, members. Thank you. So the question is that Amendment 5 be agreed. All those in favour say aye. Aye. Contrary of any noes? No. Okay. Do we have tellers? Do we have tellers? Order, members. Order, members. Thank you. So tellers have been appointed as follows. Tellers for the ayes are Emma Sheeran and Linda Dillon. Tellers for the noes are Andy McMurray and Kate Nicholl. Clear the lobbies. The Assembly will divide. Ayes to my right and noes to my left. Clear the doors. You ready, Liz? Order. Order, members. Thank you. Clerk, would you please read the result?
74 members voted, 27 members voted aye, 47 members voted no. The amendment is not made.
The amendment's not made. Okay. Amendment 6 has already been debated. And is paving for Amendments 8 and 10. I call on the Minister of Justice to move formally Amendment number 6.
Moved.
Thank you, Minister. Amendment to Clause 1, page 4, line 21, leave out and insert words as printed on the Marshall list. The question is that Amendment 6 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. The ayes have it. Amendment 7 has already been debated. I call on the Minister of Justice to formally move Amendment 7.
So moved.
Thank you, Minister. Amendment proposed to Clause 1, page 4, line 23, insert word as printed on the Marshall list. So the question is that Amendment 7 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. The ayes have it. Amendment 8 has already been debated. I call on the Minister of Justice to move formally Amendment 8.
So moved.
Thank you, Minister. Amendment proposed to Clause 1, page 4, line 24, leave out and insert words as printed on the Marshall list. The question is that Amendment 8 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. The ayes have it. Amendment 9 has already been debated. I call on the Minister of Justice to move formally Amendment 9.
So moved.
So amendment proposed to Clause 1, page 4, line 32, leave out and insert words as printed on the Marshall list. The question is that Amendment 9 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. Amendment 10 has already been debated. I call the Minister of Justice to move formally Amendment 10.
So moved.
Thank you, Minister. The amendment proposed to Clause 1, page 4, line 38, insert words as printed on the Marshall list. The question is that Amendment 10 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. Amendment 11 has already been debated. I call on Emma Sheeran to move formally Amendment 11.
Moved.
Amendment proposed to Clause 1, page 6, line 17. Insert words as printed on the Marshall list. The question is that Amendment 11 be made. All those in favour say aye. Aye. Contrary of any noes? No. I've been advised by the party whips in accordance with Standing Order 27 brackets 1AB that there is agreement that we can dispense with the 3 minutes and move straight to division. So I now call for tellers. Do we have tellers? Order. Order, members. Order. Tellers have been appointed as follows. Tellers for the ayes are Emma Sheeran and Ciara Ferguson. Tellers for the noes are Andrew McMurray and Kate Nicholl. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. The doors. Members, order. Order. Clerk, could you please read the result?
72 members voted, 25 members voted aye, 47 members voted no. The amendment is not made.
The amendment's not made. Amendment 12 has already been debated. I call on Emma Sheeran to move formally Amendment 12.
Bugha, so moved.
Thank you. Amendment proposed to Clause 1, page 6, line 21. Insert words as printed on the Marshall list. The question is that Amendment 12 be made. All those in favour say aye. Can't we have any noes? Okay, we've been advised by the party whips that in accordance with Standing Order 27, brackets 1A, brackets 1AB, that there is agreement that we can dispense with 3 minutes and move straight to the division. So I'm now calling for tellers. Do we have tellers? Members, tellers have been appointed as follows. Tellers for the ayes are Aoife Finnegan and Emma Sheeran. Tellers for the noes are Andrew McMurray and Nick Matheson. Clear the lobbies. The Assembly will divide. Ayes to my right, tellers to my left. the doors. Order, members. Clerk, would you please read the result?
73 members voted, 26 members voted aye, 47 members voted no. The amendment is not made.
The amendment's not made. Amendment 13 has already been debated. I call on Emma Sheeran to formally move Amendment 13, which is mutually exclusive with Amendments 14 to 17.
Bugha, moved.
Thank you. Amendment proposed to Clause 1, page 6, leave out from line 38 to line 15 on page 8. So the question is that Amendment 13 be made. All those in favour say aye. Aye. Can't we have any noes? I've been advised by party whips that order, please. I've been advised by party whips that in accordance with Standing Order 27 brackets 1A and B, that there is an agreement that we can dispense with 3 minutes to move straight to division. So I now call for tellers. Do we have tellers? Okay, members, tellers have been appointed as follows. Tellers for the ayes are Aoife Finnegan and Emma Sheeran. Tellers for the noes are Andrew McMurray and Nick Matheson. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. Close the doors. Okay, members. Clerk, could you please read the result?
73 members voted, 26 members voted aye, 47 members voted no. The amendment is not made.
The amendment's not made. So Amendment 14 has already been debated and is paving for Amendment 111. I call the Minister of Justice to move formally Amendment number 14.
So moved.
Thank you, Minister. Amendment proposed to Clause 1, page 7, line 12, leave out and insert words as printed on the Marshall list. So the question is that Amendment 14 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. The ayes have it. Amendment 15 has already been debated. I call on the Minister of Justice to move formally Amendment 15.
So moved.
Thank you, Minister. Amendment proposed to Clause 1, page 7, line 29, leave out words as printed on the Marshall list. The question is that Amendment 15 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. Amendment 16 has already been debated. I call the Minister of Justice to move formally Amendment 16.
So moved.
Thank you, Minister. Amendment to propose to Clause 1, page 7, line 29, leave out word as printed on the Marshall list. The question is that Amendment 16 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. Amendment 17 has already been debated and is... order, please. Amendment 17 has already been debated and is paving for Amendment 111. I call on the Minister of Justice to formally move Amendment 17.
So moved.
Thank you, Minister. The amendment proposed to Clause 1, page 8, line 7, leave out and insert words as printed on the Marshall list. The question is that Amendment 17 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. I'll not call Amendment 19 as it is consequential. Sorry, I'll not call Amendment 18 as it is consequential to Amendment 13, which has not been made. I'll not call Amendments 14 to 17. And I'll not call Amendment 19 as it is also consequential to Amendment 12, which was not made. Are you confused?
Has been taken.
Yeah, no. No, I'm going to be guided by these, Minister, if you don't mind, okay? So I'm not going to call Amendment 19 as is consequential to Amendment 12, which is not made, okay? So I will not call Amendments 20, 21 as they are consequential to Amendment 13, which was not made. I'm now I'm going to look at Amendment 22. If all that's clear, I'm going to look at Amendment 22, which has already been debated. I call the Minister of Justice to move formally Amendment 22.
So moved.
Thank you, Minister. Amendment proposed to Clause 1, page 8, line 36. Insert words as printed on the Marshall list. The question is that Amendment 22 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. The ayes have it. Amendment 23 has already been debated. I call on Emma Sheeran to move formally Amendment 23.
Mulcahy moved.
Cormac Emma, thank you. Amendment proposed to Clause 1, page 8, leave out from line 37 to line 3 on page 9. The question is that Amendment 23 be made. All those in favour say aye. Aye. Contrary of any noes? No. Okay, I've been advised by the party whips that in accordance with Standing Order 27 1A, brackets 1A and B, that there is agreement that we can dispense with 3 minutes and move straight to the division. So I now call for tellers. Do we have tellers? Order, members. Tellers have been appointed as follows. Tellers for the ayes are Emma Sheeran and Ciara Ferguson. Tellers for the noes are Andrew McMurray and Paula Bradshaw. Clear the lobbies. The Assembly will divide. Ayes to my right and noes to my left. Secure the doors. Order, members. Order, members. Thank you. Clerk, would you please read the result?
72 members voted, 26 members voted aye, 46 members voted no. The amendment is not made.
The amendment's not made. Amendment 24 has already been debated and is mutually exclusive with Amendments 25 to 27. I call Emma Sheeran to move formally Amendment 24.
Bugha moved.
Thank you. Amendment proposed to Clause 1, page 9, leave out lines 4 to 33. The question is that Amendment 24 be made. All those in favour say aye. Can't we have any noes? No. I've been advised by the party whips, in accordance with Standing Order 27 brackets 1A and B, that there is an agreement we can dispense with 3 minutes and move straight into the division. So I now call for tellers. Do we have tellers? Order, members. Tellers have been appointed as follows. Tellers for the ayes are Aoife Finnegan and Orlea Flynn. Tellers for the noes are Andrew McMurray and Paula Bradshaw. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. The doors. Order, members. Order, members. Clerk, could you please read the result?
72 members voted, 26 members voted aye, 46 members voted no. The amendment is not made.
The amendment's not made, so 25 has already been debated and is paving for Amendment 26. So I call on the Minister of Justice to formally move Amendment 25.
So moved.
Thank you, Minister. Amendment to proposed to Clause 1, page 9, line 4, leave out words as printed on the marshal list. So the question is that Amendment 25 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. Amendment 26 has already been debated. I call on the Minister of Justice to move formally Amendment 26.
So moved.
Thank you, Minister. Amendment proposed to Clause 1, page 9, line 6, leave out and insert words as printed on the marshal list. The question is that Amendment 26 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. Amendment 27 has already been debated. I call on the Minister of Justice to move formally Amendment 27.
So moved.
Thank you, Minister. Amendment proposed to Clause 1, page 9, leave out lines 22 to 33. So the question is that Amendment 27 be made. All those in favour say aye. Aye. Contrary of any noes? The ayes have it. So I'll not call amendments. Okay, so I'm going to just read this. Amendment 27 has already been debated. I call on Emma Sheeran. 28. Thanks for keeping us right, Paul. Thank you. Amendment 28 has already been debated. I call on Emma Sheeran to move formally Amendment 28.
Bugha moved.
Thank you. Amendment proposed to Clause 1, page 9, leave out lines 34 to 40. Sorry. So the question is that Amendment 28 be made. All those in favour say aye. Aye. Contrary of any noes? No. Okay. I've been advised by the party whips that in accordance with Standing Order 27, order please. In accordance with Standing Order 27, brackets 1A and B, that there is an agreement we can dispense with 3 minutes and move straight to the division. So I now call for tellers. Do we have tellers? Order, members. Tellers have been appointed as follows. Tellers for the ayes are Colm Gildernew. Order, please. Tellers for the ayes are Colm Gildernew and Orlia Flynn. Tellers for the noes are Andrew McMurray and Peter Reynolds. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. secure the doors. Okay, members, thank you. Clerk, could you please read the result?
72 members voted, 26 members voted aye, 46 members voted no. The amendment is not made.
The amendment's not made. Amendment 29 has already been debated. I call on Emma Shane to move formally Amendment 29.
Bugha moved.
Thank you. Amendment proposed to Clause 1, page 12, line 24, insert words as printed on the marshal list. The question is that Amendment 29 be made. All those in favour say aye. Aye. Can't you have any noes? Order, order, order. I've been advised by the party whip that in accordance with Standing Order 27, 1A and B, that there's an agreement we can dispense with 3 minutes and move straight to the division. So I now call for tellers. Do we have tellers? Order, members. Order. Tellers have been appointed as follows. Tellers for the ayes are Colm Gildernew and Arlea Flynn. Tellers for the noes are Andrew McMurray and Peter McReynolds. Clear the lobbies. The Assembly will divide. Ayes to my right and noes to my left. Clear the doors. members? Clerk, please read the result.
72 members voted, 26 members voted aye, 46 members voted no. The amendment is not made.
The amendment's not made. I will not call Amendment 30 as it is consequential to Amendments 12 and 13, and neither of which were made. Members, I'm conscious that there's going to be additional votes, but on the order of paper there's a suspension from 6 to 6:30, so I'm going to suspend now. And we will return again at 6:30, so the sit-in is by leave suspended. Thank you.